Pop out at your party with the gang. Gonna be a robbery, so tuck your chain. Hey guys, it's me, Lauren Cadillac, aka OG Cadillac, aka Mother of the Decade, aka the best lawyer in Dallas, Texas. No, all of Texas. Good morning. Good morning. All right, guys. Ooh. I got the tracking thing back on, but Lynn taught me how to do it. I hope y'all can hear me okay. We have a new output rate on the thingamajigger. What is this? The cam. So we have a new output rate. Hopefully that is better. Hopefully everything is better. Good morning, everyone. There's so many of you here already, and it just like tickles my heart. Thank you so much for being here. I'm so excited to see you all this morning. I know that so many of you waited to learn about these pleadings. You waited for me. I know that, and I appreciate it so much. And I'm so glad. I'm so glad we can all be here together. Welcome, my trial geeks. Today I have on jewelry that was handcrafted by my son when he was 6. That'll look good with the top. I am drinking coffee, but I'm going to be quitting that. I've only had it like 4 days. Oh my god, this stuff is addictive though. Now I understand why all y'all drink coffee, because like you have it one time and you just want it again and again. This is the kind with all the chocolate and sugar in it. Ooh, it's delicioso. Delicioso. Okay. Well, the last time I saw y'all was last Friday. Oh, you hear that thumping? Sorry guys, let me eradicate that background noise. I'm so sorry. All right, so we saw each other last Friday and we met our new judge and we watched her like actually make rules. We saw her like actually be a judge, and she gave everyone a deadline of Tuesday to write their motions and then a deadline of today to respond to the motions. As I understand it, the state has already responded to their motions. I haven't seen all the responses from the YSL teams, but I'm sure those will be coming today and maybe even while we're online. So we'll get to those, hopefully. Okay. Okay, good, I'm glad. 4 cups of coffee, holy shit. I wouldn't be able to sleep. I mean, this one cup of coffee is like, ah! Wired. Totally wired. Totally wired. Thank you, B. Those stickers, I actually have a link to the artist who made them for us. This is Belin's sister. You know, Belin does all our thumbnails. Belin is the Shaquille Kokomo of Cadillac law, okay? So much so that Megan Cuniff did a interview with Max Schardt, and in the interview, Kokomo kind of like peeks his head into the camera, right? That is exactly how Belin peeks her head into the camera when we're on a meeting. So Shaquille and Belin are one and the same. And I've been watching the ballerina who killed her husband. I've been watching hers, and he has a Belin as well. He has a Belin as well. That's what we call him. They're Belins. So Belin's sister made those great stickers. Thank you for everyone who's joined the membership. Thank you for everyone that's here, everyone that supported us. This is fantastic. This is so fun. It's my favorite day of the week when I get to see y'all. Okay. Let's get into it, y'all. Let's get into it. Now, I don't think 7:23. I'm trying to see, like, should I read these in chronological order? Oh. Remember, the judge said these motions are due on Tuesday. I'm not going to read this one yet because it's the last one, so it's going to be the last one I read, but look here. 11 p.m. 11 p.m. This state, this group of ADAs with the state is actually incapable of doing their job. They are actually incapable. 11:51 p.m. is 9 minutes before past the due date. This is the same ADA that needed an extra 48 hours to write a 15-point Calibri motion. And all of her responses are, it is very clear. Well, hold on, let me back up. Writing and the research, that's not my favorite part of my job. Okay, my favorite part of the job is in the courtroom, making objections or getting ready for the courtroom even. But, you know, out here writing these motions and stuff, I do it decently, but it's not my favorite part of the job. I always feel insecure about it because I don't love it. Like, the things I love, I know I'm great at, right? But the things that I don't love, I feel like, oh, maybe I'm not the greatest. Reading Miss Love's writing makes me feel so confident. It makes me feel so confident. Like, oh, I'm good. I'm good. I'm good. I'm so good. I'm so good. She was a judge. So I'm good. I'm real good. Okay. Let's get started. I can't expand this one. I don't know why. All right, this was filed on the 19th, which was last Friday. So it was the last time we saw each other. This was filed. Motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12, 2024. Wow, y'all. Sometimes I'm like, damn, I cannot believe it is 2024. That's crazy. Okay, Williams through his counsel. Williams is innocent of the crimes. On the afternoon of July 12th, Weinstein filed the recusal motion. If a party files a motion to recuse a trial judge and the motion's denied, but it's later determined the judge should have been disqualified to act in the case, all proceedings after the filing motion are invalid and have no effect. In the case at bar, Glanville denied Weinstein's timely following on June 12th, as well as Williams' filing on June 17th. Since these motions to recuse had merit and were granted, all proceedings that occurred after the filing of Weinstein's motion from June 12th to June 1st, when Glanville stepped away for, after filing through when Glanville stepped away, which includes the testimony of witness Copeland, exhibits admitted and displayed to the jury, Judge Glanville's ruling on evidentiary issues, and the like, must be erased forever in toto from the jury's mind, and any rulings that occurred in front of and outside the present jury are invalid. It's like they want the like the Men in Black thing, you know, like, can we just Men in Black them and just erase everything they saw after June 12th? I don't think so. How do you undo that? Like, how do you, first of all, this jury, when they come back, it's going to have been 2 months since they were there. So I'm guessing they won't remember a damn thing. I certainly wouldn't. But how do you undo what they've heard? Oh, you know, just ignore everything Copeland said. Oh, you know, that video that you watched that had all that hearsay in it, just ignore that. Like, how do you do that? How do you unwind this? And we're going to get into that with Weinstein's motion. We're going to get into that Weinstein's motion. Belin's telling me the state just filed motions 30 minutes ago, so she's going to send me the links, and we'll be able to see those. So we're going to get into, can the jury unhear things? But I don't think things can be unheard. I mean, think about your relationships, right? Like, think about your partner, your significant other. And if they say something really nasty about you, like you snore at night, even if they're like, no, I was kidding, and like, you can't undo that. You just accused me of snoring. So that's how I think the jury will take the Copeland. Like, you can't just undo the I don't know. I don't know. Okay, so That's our first motion from Steele. Steele was on a roll on Friday, though, okay? He was like, I'm not going to enjoy this weekend until I have as many motions as I need filed. Good for him. Kudos. God, this coffee stuff is like crack. Jeez. I totally understand it now. Ooh, Mrs. Mondo's here. She's an OG. Thank you for joining us, Mrs. Mondo. Happy to see you. Okay, so Belinda's going to email me these files, and I'll open them here in a minute. Good morning, everyone, and thank you for joining us. If you're just joining, all you missed was Steele's motion to undo everything that happened after June 12th. Luckily, as I recall, most of what happened after June 12th was outside of the presence of the jury. Yes, there was some Copeland testimony, but you remember there were like the days and days of us like watching the cop interviews. So I think a lot of it is like more legal, and so I don't know. It's good. It's a mess, y'all. Okay, here we go. Here is Steele's second motion of Friday. Motion to challenge factual findings, not result, of the Honorable Judge Krause order dated July 15th, granting the motions to recuse Judge Glanville. Okay, here comes Jeff. Jeffrey Williams is innocent. Krause made two findings that are respectfully erroneous in her order. First, she called my work hyperbole. It is hyperbolic. Is that like how you say it? Is that, it's like very full of hyperbole, okay? Like, it really was. It was, remember, I told you guys, part of the reason I love Steele's writing is because it's so dramatic. It has such a dramatic flair to it. So there was a lot of hyperbole, okay? Then Steele says, the second part is where she says, it's worth noting that Krause agrees generally with Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting was inherently improper. And if you remember, when we went over this order, I said, that's very interesting. She kind of added that. That was never really at issue. She just kind of threw that in there to support her buddy. Okay. So now Steele is saying that, like, hey, this doesn't belong here. Okay, this finding is wholly against the law. Well, there we go. He's saying she's not even allowed to do this. It was sua sponte. Remember, you guys have definitely learned sua sponte. Like, all of you should know what sua sponte means. It means on her own. So on her own, without being asked, without any legal reason, she just added that, right? At this improper ex parte hearing, Williams and his counsel had a right to be present for several reasons, including but not limited to, Copeland provided statements bearing the substance of his testimony, but also his credibility. There was enormous amounts of Brady evidence shared at this ex parte meeting, and there was no lawful reason for the get-together, this ex parte get-together. There are more reasons that these findings by Krause are completely erroneous, but same do not affect the outcome of the correct ruling recusing the previous trial judge. Okay. That's our boy Brian Steele. All right, so he is saying, yo, we've had this problem. They shouldn't have had the meeting. We need to have these pieces of this order struck. Because remember, the order makes it so, right? Like, when a judge orders it, it is so. If a judge makes an order, the sky is green, the sky is green. That's the order, right? Like, that is it. So he wants that removed because her having, Krause putting a finding that the ex parte was appropriate, then obstructs and puts a impediment in the way of Steele et al. From asking for the mistrial. And so you want to strike it because it wasn't before her. It's totally not her business. And she is basically saying that the ex parte was okay. If it was in fact okay, then there is not the ability to have a mistrial. And they want, well, they kind of want the mistrial, they kind of don't. I'm trying to open the next, sorry guys, me and computers are like, God bless, like me and computers do not get along. Oh, by the way, I dug out this old playlist of mine, and it turns out I do like another Young Thug song. It's called Hot, and it features Gunna. And I just love that beat. I don't know what they're saying, but I love the beat of that one. So there is another, I'm not a total not Young Thug fan. I just don't follow. Like I only have like 4 songs. And the other hip hop songs I know all came from my son, like the Polo G, Pop Out at Your Party. Like that's old, but it came from my boy. And my son doesn't live with me anymore because he's at college now, so I don't get any of that. Okay. Let's move next to Deamonte Kendrick'c's motion for mistrial. All right. Y'all need to know how much I love you. I love y'all so much that we registered for the Fulton County court portal so we can obtain documents. We have to pay for them, and that's the other thing. I paid $7 for this. This is how much I love you guys. I paid $7 so I could have this document and read it to you, okay? So don't nobody ever say Lauren Cadillac does not love her audience. Okay, the beat is what matters, y'all. Like, the beat is what matters. And I noticed that all of the, like, the 18 rap songs I like, of modern, I love, like, 90s, so don't go there. But, like, the 18 modern songs I like, they all kind of have the same hard beat. I don't know if that makes sense, but, okay. Okay, so, back to my love for y'all. Here it is. This cost $7, and I bought it so I could share it with you. Okay, here we go. Deamonte Kendrick'c's motion for mistrial. This is Yak Gotti. I really like Weinstein. Remember, I've said he is the perfect example of quiet and like deadly. Like, dude doesn't talk much, but when he does talk, ooh, he be dropping some bombs. Oh my God, I love it. I love it. Okay, so here we go. I try personally, when I'm making an argument to the court, I try to open with like a quote of law, like a statement of law, to suck my judge in and show my judge like I'm the best. And so I love that he does this block quote. And dude formats very well. He may have read typography for lawyers. He might have, because his formatting is beautiful. Look at this font. It is so easy to read. I just love it. I love it. And when we go to the state's motions, we can see there's a stark difference. Okay. We think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act, or the ends of public justice would otherwise be defeated. They are to exercise sound discretion on the subject, and it is impossible to define all the circumstances which would render it proper to interfere. But, after all, they have the right to order the discharge, and the security which the public have for the faithful, sound, and conscientious exercise of this discretion rests in this, as other cases, upon the responsibility of the judges under their oaths of office. Fake mic, drop it, guys. Mic drop. Just comes right in. Hit you with that case law. Love it. I love it. Love The state has had witness after witness fail to provide the testimony that it would like the jury to hear. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its own witnesses, including at least the following key witnesses: Trontavious Stevens, Walter Murphy, Archillian Bennett, Eduardo Nava Flores, Adrian Bean, D'Angelo White, and critically, Kenneth Copeland. Hold on, I just gotta go back here. I just gotta go just admire right here. This, can I highlight this? Can I highlight? Yes. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of its own witnesses. Y'all go back to my impeachment video. I know a lot of you who are in the chat right now, you already watched that. What did we talk about? I said I don't impeach my own witnesses. Sometimes I might refresh their memory, but why would I impeach my witness? Impeaching is to show that the witness is not reliable. Thank you, Sunshine. I actually washed my hair today. Y'all, when your hair is like 10 feet long like mine, like twice a week is a lot, man. All right. We'll get back to Weinstein. I love this guy. Like, and then I've been seeing him on interviews, and he is just great. He is to me the kind of lawyer we need in a courtroom, a defense attorney. It's beautiful. What is the state to do? I'm sorry, I just love it. Losing its case, apparently unconcerned about the need for public justice. Remember, what did this quote say? What does this quote say? Public justice. He quoted it. It says the need for public justice. He goes, they're unconcerned with the need for public justice. That is proper writing. That is good writing. Yeah, K-Way, literally everyone but the cops has been impeached. Everyone but state actors has been impeached. The state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick that he would have no choice but to request a mistrial. Let me translate to you what that says in normal person. That says, the government was trying to prosecute my client. They knew they were losing, so they had this inappropriate meeting so they could get a restart. If that is true, if that was really the intent of Love and Hilton, that they would purposefully do this so that they could start over because they know they're losing? Wow. Wow. Okay. Now, goaded by the state and the actions of Chief Judge Glanville, Kendrick has no option. He's forced. He's backed into a corner, y'all. But to move this court for a mistrial, to respect the constitutional rights of Kendrick, and not defeat the ends of public justice. So he's saying, look, Judge, they said the court has cited ends of public justice as something very important. And you don't want to be the judge that violates this. This is so important. And he's repeating the quote. He's carrying the theme. A lot of you had not yet found me when I went over the opening statements. But my favorite opening statement was from Max Schardt, and the reason was he set a theme. He talked about Fulton County blue, and he repeated Fulton County blue, and people don't want to wear Fulton County blue, right? So, the theme and the carrying of a theme shows that you're a really good attorney. Like, we're supposed to carry a theme. So I love how Weinstein's carrying this theme. It's gorgeous. While this trial has been riddled with scores of errors, at least 3 demand an immediate mistrial. Do you guys remember being in like 5th grade and having to write like a 3 to 5 paragraph essay? The reason I can ask is, like, my daughter just graduated 5th grade, so she's a rising 6th grader. But I was helping her write her little essays and stuff. And if you recall, you have a thesis statement at the beginning paragraph. Then you have your 3 kind of body sentences that link to the thesis. Then you write a sentence that helps you transition to the next paragraph, and then the thesis, and so on and so forth, right? This is masterful. This is exactly what your English teacher was trying to get you to do, okay? While this trial's been riddled with scores of errors, at least 3 demand immediate mistrial. So you're closing out the paragraph and moving into the points. I'm telling you, every English teacher ever loves Douglas Weinstein. Like, oh my God, this is exactly what we were begging these children to do. It's hard though, it's not easy. So this guy is a good writer. He is very talented. First, placed in an impossible position by the state, this court is faced with the task and requirement to reset this case to at least the point the afternoon of June 12th, when Kendrick moved for Chief Glanville to recuse himself, and he improperly failed to halt all proceedings pending the determination of recusal. Since that date, the jury heard days of testimony from Copeland, testimony that cannot be unheard. So what we talked about, guys, how is the judge going to erase their memory? How are you going to rewind? I don't know. Second, Kendrick's constitutional rights were violated when neither his nor his attorneys were present at a critical stage of the proceedings, the secret ex parte meeting among the state, Glanville, Copeland, state investigator, court staff, and deputies. Third, Kendrick's due process rights were violated when Glanville wrongly coerced Copeland to testify. I don't know if you remember, but in that meeting, in that ex parte meeting, Hilton was misquoting the law and Glanville was going along with it. And they were doing that in a way to get Copeland to say, okay, I'll testify. None of the 3 reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. That is the opening. That's the opening. Beautiful. Honestly, I'm gonna just like download. I'm just gonna download Weinstein's filings because he writes so well. They're so good. My God. Okay, background. In January 2023, nearly 18 months ago, trial began in Fulton County Superior Court in State versus Deamonte Kendrick'c et al. Oh, he didn't put the dots. You're supposed to put ET period, AL period, but okay. Jury selection took more than 10 months with the trial before the selected jury beginning November 23. 10 months for jury selection. That is unheard of. That is ridiculous. I love watching Mr. Bruce Rivers, the criminal lawyer. He said that 1 month would be a long time for a jury selection on a trial like this. Now, I don't do criminal defense, okay? I am a litigator. I do civil work, mainly real estate related stuff, okay? So the longest my jury selection has ever taken was like an hour, I think. That was because there were other people asking them questions. I already knew from the jump. I see them walk in, look at me, I get a sense, okay? One of the benefits of having been an abused child is that you're really good at reading people, like understanding their mood, you know, and getting their vibe, so I hate that word, but you understand. Okay, back to this beautiful piece of writing. A secret ex parte meeting was held on June 10th, and we know it's secret because Glanville didn't get upset. He got upset about who had revealed the information, so we know he meant to keep it secret. Okay? At the secret ex parte meeting was held on June 10th. In attendance were Glanville, Copeland, Love, Hilton, and investigators from Fulton County. A central figure, perhaps The central figure in the state's case against Kendrick and other defendants is Copeland. On June 7th, Copeland was sworn in. After being given a grant of immunity and being warned by Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the Fifth. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Defense counsel were told to be present in court at that time and were, in fact, present. Unknown to any member of defense counsel, an ex parte proceeding was held in Glanville's chambers on that date. We know the attendees. No member of defense counsel was present, despite Copeland's invocation of his Fifth Amendment right and the meeting being a critical phase of the trial. Neither Glanville, any member of the court staff, nor the DA's office made any member of the defense counsel aware of the meeting before, during, or after the proceeding. Several defense counsel were later made aware of the ex parte proceedings with sworn witness Copeland, though not from Glanville or the DA's. Critically, Brady material was disclosed in the ex parte proceedings and withheld from all defense counsel. A review of the recently released transcript of the ex parte proceeding reveals the occurrence of the following events. Now, personally, I wish he had numbered these, but a bullet is fine. All right? Copeland announced that he would invoke the Fifth Amendment right not to testify. Copeland stated he would rather sit in jail for 2 years than testify. Glanville informed Copeland that Glanville could keep the sworn witness incarcerated until additional defendants were tried, not just the 6 currently on trial. Copeland was informed that there were over a dozen defendants left to try. Following the above coercive actions by Chief Gov Glanville, working in concert with the state, sworn witness Copeland stated that at the ex parte proceedings that he would testify. Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the proceeding. Copeland stated he would lie on the stand. Now remember, we talked about this. A judge, a lawyer that knows someone is going to lie on the stand cannot call them. You can't just call someone onto the stand that you know is going to lie. And when the judge knows they're going to lie on the stand, that's a whole nother set of circumstances. Lying is fraud on the court, and the court cannot allow that. The state never gave Kendrick these critical Brady materials. These troubling facts not only implicate Chief Judge Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Following the secret ex parte proceeding, petitioner filed and presented a motion to recuse, accompanied with an affidavit from Douglas Weinstein to Glanville on the 12th. The motion was based on the impermissible secrecy of the ex parte proceeding and violations of judicial code of conduct that occurred during the secret proceeding. The motion was summarily denied in stanter with a formal order issued on June 14th. Despite meeting all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure of USCR 25.3. A formal order denying the motion was entered on June 14th, 2 days after the recusal was filed. On July 1st, Glanville reversed his order of June 14th and referred Kendrick's motion to recuse to another judge to determine the merits of Kendrick's recusal motion. On July 15th, Krause recused Glanville. Okay. K-Way says it's not lying unless you tell a bold-faced whopper. And that is exactly what the judge said in this freaking meeting. It is unbelievable to me to see a judge behave that way. Especially someone who's in their 50s like Glanville. It's like crazy. It's just absolutely crazy. It's crazy. I would think younger people maybe because they're like on TikTok and it's destroying their mind or something, but someone in their 50s judges should not be behaving the way we saw Glanville behave. So I'm going to take a brief moment to talk about our schedule. On Monday, they are going to resume in the trial court for YSL, and they will present these motion arguments. There is a chance that the judge calls a mistrial. If that's the case, I will come on live right away, okay? I will, because on Monday, I'm just doing stuff to get ready to leave for vacation on Tuesday. So if there is a mistrial called, I will come on live right away. We will chat about it. All right. If there is not a mistrial called, I am going to go live about the ballerina murder, which is this woman who was a ballerina. She was 30 years younger than her husband, and she killed him in self-defense. And so she's on trial to determine, you know, was it self-defense or whatever, second degree. I've been watching it, and this shit was premeditated AF. I think she premeditated that from the day they met, but, you know, whatever. So we'll talk about that on Monday if there's no reason to go live on YSL. And then on Friday, oh shit, Tuesday is when okay, my bad. They go back on Tuesday. So on Monday, I'm going to come live with you to talk to you about the ballerina murder, and we'll recap that. Okay, so then Friday of next week, even though I'll be on vacation with my sweet little baby daughter, I will take some time out to go live, but it'll be a really short live. Hopefully, it's a short live about the mistrial that gets called. And I say that because I do believe that this, the ex parte meeting gives rise to mistrial. And so I say that not as just because I'm a fan of, you know, not the government, just because I'm against the government. I say that because I really do believe that there should be a mistrial. Okay, so then August 13th, I will be in Atlanta. If this trial is going on, we will meet in the courtroom that afternoon. If this trial is over, which we'll talk about what I think the judge is going to do in a little bit here. If this trial is over, we'll just meet at the meet and greet at Hudson Grill at 6:30 p.m. Okay? Cool, cool, cool. Thank you guys. The vacation's going to be great. We're going to Canada. We're going to go whitewater rafting. We're so adventurous, aren't we? I'm just kidding. We're not that adventurous. I just live in the city, and I got to get out of the city. I got to go to nature every so often. All right, let's get back. Okay. Now, my only issue with Weinstein's formatting is that I do wish this was bold. I do think headers should be in bold. I understand he underlined. That's fine. But I prefer bold. That's all. That's all. Just tiny little, you know, whatever. I feel like if he had read typography for lawyers, it would be in bold. That's what I feel. Okay. The Honorable Court is now faced with the unenviable and impossible task of rewinding the case to the afternoon of June 12th. Okay, he cites what I already read you from Steele's. So this is the law. The law is once the recusal is filed, it should pause until it's determined if the judge is actually in fact disqualified, and that is because anything that happens if he's later recused is undone. So he should have paused it that day. And Weinstein told him that. Weinstein told him, I remember Weinstein saying that, and judge didn't do it. Okay. Kendrick moved chief judge to recuse during the afternoon of 12th, and he denied. Critically, judge failed to follow this by not halting proceedings and sending the recusal motion to another judge. Subsequently, Krause, on the 15th of July, so a month and 3 days later, found that Glanville should have been disqualified. Therefore, all proceedings since the afternoon of June 12th are invalid and have no effect. And that's just the law. That's a fact. So there's no doubt that everything from June 12th forward has to be redone, has to be undone, and then move forward with a clean slate. There's no disputing that. That is the law. That is what they have to do. Okay, so now the question becomes, can we really do that and still have this jury consider these issues? The court is now saddled with the repercussions of Glanville's failure to follow Rule 25. He should have halted the proceedings and referred it for reassignment. Nevertheless, he persisted. I got that tattooed on my arm, actually. Oh, can't see it. Anyhow, I have nevertheless, she persisted, tattooed on my arm. So, when I saw that, I was like, yay, how cute. Okay, under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days, the remainder of the day on 12th, 13th, 14th, and 17th. During that time, Glanville, who should have been disqualified, repeatedly ruled against Kendrick and other defendants on multiple objections regarding the questions of Copeland. Now the court is tasked with unringing the bell. How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days from the jurors? How can the jury unhear days and days of testimony? This is not a matter of a witness uttering a single statement that a court instructs a jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. Instructing someone not to picture flying elephants only results in the listener conjuring images of Dumbo. I love it. I love it. I love it. Given the impossibility of erasing the proceedings since June 12th, proceedings that are void due to the state knowingly, improperly requesting Chief Judge Glanville hold an improper ex parte meeting with a sworn witness, and Glanville subsequently failing to halt the proceedings, this honorable court has no alternative but to declare a mistrial. I believe that. I don't... What else do you do? How do you have a jury come in and be like, oh yeah, I'm your new judge. All that shit you heard in June, just ignore it. Give me your notes, hand them over, I'm going to tear them up. That didn't happen. And in particular, how could you go back to the jury after this month-long break and say all that to them and then not have them Google what happened? If they haven't already figured out what is going on in this case, certainly telling them to ignore all that testimony would drive them to look that up. And could you fault them? I don't think so. Like, they're not supposed to do that, but we're humans. And if you had me just sitting around for 2 months, I would look it up. Maybe I wouldn't. Maybe I wouldn't. I don't know. I just can't imagine. I can't imagine that they haven't looked something up already. I can't imagine a world where we carry around these cell phones, my fake cell phone, my fake microphone. We carry around these cell phones and they give us news alerts based off our location. I can't imagine a world like that and the jury not seeing something about this case. Okay. This motion for mistrial would not exist absent the state's requesting the improper ex parte proceeding. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick in this position. I think that's pretty true. Okay, again, I wish this was bolded, but I'm not editing here. Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret ex parte meeting among the state. Defendants were not provided notice of the hearing. Under both federal and state constitutions, a criminal defendant has right to be present during critical stages of trial. That right there is why the judge couldn't make a bond ruling last Friday. Remember, last Friday, all the lawyers were there, but none of the defendants, right? And so the judge said, we're just going to be doing the lawyer stuff. We're not going to look at the bond and those kind of motions because the defendants have to be here. Because those are critical stages. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. Or even just talk to about testimony. I mean, you could just say being spoken to about testimony. A critical stage is one in which a defendant's rights may be lost, defense waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some way or another. If your bond hearing requires you to be there, then having a meeting with a sworn witness would also require you to be there. Here, The outcome of this case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. Copeland is the key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas. While the case against Kendrick is weak at best, even with the testimony of Copeland, without Copeland, the state has virtually nothing attaching Kendrick to the murder of Thomas. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick had a right to participate. A mistrial should be ordered by this court, given that Glanville denied Kendrick's constitutional right to be present. Furthermore, this mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Kendrick into moving for mistrial. And they did damn well know that. You know, no human who goes through law school and passes the bar has any question that an ex parte meeting is inappropriate, particularly without telling the defense. It'd be one thing to say, hey, we're going to have this ex parte meeting with the judge about these security issues. But they didn't say anything, and then the judge tried to cover it up. Okay. Copeland's testimony is tainted. Y'all, there are several words that during law school you just kind of laugh at. Okay, like penal code. It still makes me laugh. I'm in my 40s and I giggle every time I hear it. Taint is one of those too, like tainted evidence. I don't know. It's just one of those silly, yes, I'm an adult, but no, I'm not an adult. Tainted is one of those words for me, okay? Copeland's testimony is tainted by the improper meeting prompted by the state where Glanville wrongly coerced Copeland to testify. Chief Judge Glanville's coercion of testimony by sworn witness Copeland in the face of Copeland's repeated refusal to testify and Copeland's statement that he would lie on the stand is an act of impermissible intimidation and violation of the Judicial Code of Conduct. Kendrick's constitutional rights to due process and a fair trial have been violated by the above actions, and the state's actions in working with Chief on the coercion has intentionally goaded Kendrick into the only possible outcome, this motion for mistrial that should be granted by this court. As a natural result of the state's actions, Glanville has violated multiple rules of the Code of Conduct, the violation of which denied Kendrick's constitutional right to due process and a fair trial. As requested by the state, Glanville had an improper ex parte proceeding conducted with sworn witness Copeland. The secret proceeding with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Conduct, which assures every person a fair hearing. Ex parte communications are presumed to have been in error. Ex parte communications are presumed to have been in error. There is a presumption that that meeting is an error. And when you know of an error, particularly a reversible error, you have to call a mistrial. Likely prompted by the state, not only did Glanville fail to notify defense counsel about the proceedings as required in Rule 2.9, but Glanville made every effort to conceal the proceeding. That's what I was talking about. He tried to hide it. Glanville should not have coerced sworn witness Copeland to testifying. A trial judge should not intend to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. The situation in the present case is analogous. I hate that word. You could say an analogy. Why not just say an analogy? Why you gotta say analogy? I hate that word. While in Webb, a trial judge intimidated a defense witness into not testifying. The corollary is present here, where a trial judge, Glanville, intimidated the state witnesses into testifying. Supreme Court language in Webb is instructive. In reversing a conviction, the court said that, in light of the great disparity between the posture of the presiding judge and that of a witness in these circumstances, the unnecessarily strong terms used by the judge could well have exerted such duress on the witness's mind to preclude him from making a free and voluntary choice of whether or not to testify. Case law. Right here. He's got case law to back him up. Here it is. This is not just Doug Weinstein saying this is how you should do it. This is the law, judge. This is how legal writing is supposed to look. This is what legal writing is supposed to look like. I'm going to read a state's motion right after this so that we can see the immediate contrast, okay? That same disparity occurred with Copeland. A trial judge in his chambers, in cooperation with prosecutors, surrounded by investigators and law enforcement, coerced Copeland with the threat of years of jailing. The state and the judge exerted such duress to preclude Copeland from making a free and voluntary choice whether or not to testify. Thus, Kendrick, who was neither present nor represented at the ex parte meeting, was deprived of his 14th Amendment right to due process. So, the 14th Amendment basically made the first 13 amendments apply to the state. Okay, so the 14th Amendment is kind of a repetition of, 4, 5, and 6, but it forced it to apply to the states. Okay. As in Webb, this court can't repair the infringement of Kendrick's due process rights under the 14th Amendment. Regardless of whether the violation was under Webb or Wynne, Kendrick's rights were violated by the judge intimidation and coercion of Copeland. As the state likely expected, Kendrick has now been goaded into seeking a mistrial because of this due process violation and, respectfully, regretfully, requests the mistrial. So Weinstein's saying, the state knew this was going to come, and they did it on purpose. That's quite the assertion. Wherefore, Kendrick respectfully and regretfully requests this court to declare a mistrial based on the practical impossibility of voiding the case after June 12th, violation of his rights, being absented at a critical stage in the proceedings, and or the tainting of testimony by Copeland, the improper coercion of his testimony by Glanville. Furthermore, Kendrick requests this court find that this request for mistrial was goaded by the state when it was requested that Glanville hold the ex parte meeting, absented Kendrick from the meeting, and join with Glanville on the coercion. Okay. So the reason that this language about being goaded by the prosecution is important is because double jeopardy. So what Weinstein is saying is we can't go on, and since the state caused this mistrial, you need to dismiss it with prejudice. Double jeopardy will apply. Okay. Good time to break to see the comments. Let me see what's going on, y'all. Let's see, any questions? Yeah, so we're going to get into the prosecution's response. And I want to just tell you that there is no doubt in my mind that these prosecutors have been running under a judge that just gives them whatever they want. That they don't actually have to do their job, that the judge is just siding with the prosecution. I'll show you why. Let's get into it. Here we go. State's response in opposition to Defendant Williams' motion to challenge factual findings. Okay. Firstly, notice the font. It is not 400 point Calibri, right? It is normal Times New Roman 12. So we're like, oh, maybe Adrienne Love has something to say. No, she does not. Also, notice they put Judge Paige Reese Whitaker, okay? That would piss me off if I was the judge. You could just put Judge Whitaker. Let's see. Everybody else just put Judge Whitaker. So why is the government putting my whole last name? Do not use my whole government. My name is not a weapon. Okay, so you're not going to use the name Lauren against me the way they're now trying to use Paige Reese Whitaker. Just say Whitaker. So disrespectful. Ugh. But at least it's in normal font. Okay, hold on. That's not the one I wanted. Nope. Where'd it go? Here we go. Okay, here's the response. This is the state's response to Jeffrey Williams, aka Young Thug's, request that the judge edit Krause's order to take out the factual findings that nobody asked her to make. All right. Following a recusal of Glanville, okay, at first, well, I guess it's because of response, so they didn't say, here comes the state, but usually there's some kind of formalities that you write, but whatever. Following recusal of Glanville, precipitated by motions from defendants Kendrick and Williams, Williams has filed a motion to challenge the factual findings made by Krause in her order recusing Glanville. For the reasons cited below, the state respectfully moves this court to deny the relief of Williams' motion request and support this motion. The state shows the court as follows. Defendants filed their motions on July 17th. Krause ruled on the motion. I thought her order was signed July 15th. Okay, legal authority. Rule 25.6 governs the requirement for recusal, and the rule grants the judge to consider a motion to recuse discretion to consider. Considering a motion to recuse discretion to either rule on the motion considering solely the affidavits or to convene in an evidentiary hearing. 25.6 requires the judge considering the motions to recuse rule on the merits of the motion and make written findings and conclusions. Krause considered the motions to recuse solely on the affidavits submitted by defendants. And, as required by law, Krause included her recusal order written findings of fact and conclusion. Well, I guess they do need to make written finding fact and conclusions of law. Fine. Even when a motion... Oh, sorry. Where... Oh, you guys, I keep doing this. I have this weird thing saved, and every time I try to hit back, it opens this... I'm sorry. It's so annoying. Okay. Even when a motion to recuse has no merit, if a judge is perceived as refuting a charge of bias, the judge's action creates a basis for recusal. Krause wrote, in transferring the case to another judge for consideration, Glanville necessarily determined that recusal might be authorized if the facts in the motion were assumed true. Glanville was prohibited from opposing the motion. Krause agreed generally with Glanville's assessment of the propriety of the ex parte meeting, but found that Glanville created a basis for his recusal when he added facts, provided context, questioned the veracity of allegations, and otherwise explained his decisions and actions and argued why those actions were proper. Krause found... Okay, so she's just quoting Krause's order, as if Judge Whitaker does not have a copy of the damn order and read it herself. Fine. Okay, lack of authority for Williams' motion. I do appreciate that she bolded her headers, all right? That's all I appreciate about this. Williams asserts that in his filing that Krause made two findings that are erroneous. First, he objects to the order's reference to his motion to including hyperbole. The reference to hyperbole is accurate. More importantly, the reference to hyperbole is not itself a factual finding. It is not a material issue for litigation. I actually agree with her here. It is full of hyperbole. It is very dramatic. It is very dramatic, and that's why I loved it. That's why I loved it. And she makes a very good point. Finding that it's full of hyperbole does not have anything to do with the case or a factual finding or anything that is subject of the litigation. So that is a point. But notice that this point is not supported by case law. This point is not supported by the rules. It's just a point. Second, defendant asserts that Krause's finding in the hearing chambers was not improper is wholly against the law. That assertion is clearly incorrect. The hearing in chambers was regarding a witness's immunity and compelled testimony. Yeah, it did. It compelled the testimony through threats. Such a hearing without defense present has been held to be proper by the Supreme Court of Georgia, which has ruled the defense has no standing to be present at such hearings. Let me go read these footnotes. You know I don't love footnotes. Okay, the first footnote, wholly against the law, she just cites his motion. Okay, then the third footnote here. Allen v. State, as authority for ruling, the appellant had no standing to contest the grant of use of immunity. I'm sorry, I started reading and I'm like, what? Okay, first of all, they're not contesting the grant of the use of immunity. I didn't see that anywhere. I didn't see them say immunity shouldn't be used. I don't understand why she would even cite that. Then she says, ruling that after appellant complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use of immunity that would apply to compel testimony, the hearing in question was not a part of the proceedings against appellant, and while appellant may have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia that would have permitted him to object to the state's request for the order or that it would suggest the rights were subject. I'm just guessing that in this other case she cited, the sworn witness wasn't sitting there. The witness probably hadn't been sworn in yet. Oh, and then her conclusion. For the reasons stated above, the state moves this court. Do y'all see what I'm saying? Do you see the difference that I'm talking about here? Do you see Weinstein comes in with statute, case law, citations. Weinstein's hardly using any of his own words. The state, on the other hand, has 3 sentences. The Miss Love's writing shows me, as an attorney, that she is used to working under a judge who will always side with her. Whether or not the law represents what she's wanting, she's getting what she wants. That is how she writes. She writes as if she doesn't have to make argument. Just saying. Here in Dallas, the way it works is each prosecutor is assigned to a judge, basically. So you start to get close to the judges, start making a friendship. I think Miss Love has just been floating along, having a judge that does whatever she wants for her. That's how she writes. Yeah, I'm speculating, of course. I don't know this for a fact, but that is how she writes. And that is how Glanville behaved. So I'm just kind of putting 2 and 2 together here. Okay, we have so many motions. We have so many motions to go through, you guys. 1, 2, 3, 4, 5, 6, 7, 8. Okay, we're gonna get through it. We're gonna get through it. I wonder sometimes, do you get sick of me reading? Do you get sick of my voice? I do. All right, here we go. Now, we are now going to move to Max Schardt. I like reading Max Schardt's writing because he writes very much like he speaks. I can hear YSL Schardt in my head as I read the motion. Okay, so I hear Schardt, and I don't know. I think he's a good lawyer. He doesn't always, come in the way I would want to see someone come in, but he does always arrive at the conclusion. So here we go. This is a motion for fair and constitutional trial. First of all, nobody should ever have to write a motion for fair and constitutional trial because we are guaranteed a fair and constitutional trial by virtue of being citizens of this great country. Full stop. We are Americans. We get a fair and constitutional trial. Full stop. So the fact that I'm even reading a motion where someone had to ask for this out loud is pretty whack, okay? All right. Comes now Mr. Shannon Stillwell, by and through undersigned counsel, and hereby files this motion for fair and constitutional trial in the above case. In support of the motion, Stillwell shows as follows. He's accused of multiple felonies, including conspiracy to violate RICO law and substantive felonies in this indictment. He is factually innocent of all the charges against him. Like all citizens, he's guaranteed a fair trial and due process trial by the federal and state constitutions and the Confrontation Clause, the Due Process Clause, and all other constitutional protections. Mr. Stillwell demands that this trial be conducted in a fair and constitutional manner. The state is seeking a life without parole sentence for Stillwell if he is convicted, and Stillwell's constitutional rights must be protected without exception. Period. Period. He could have wrote full stop. That's what I would have written. Stillwell and his co-defendants have been in trial for 19 months. 75 witnesses have testified so far. Stillwell has remained in jail for the duration of the trial. Glanville has been the trial judge up to this point. This case has been plagued by discovery violations, lost and missing police reports. Don't forget, Schardt is obsessed with these police reports, as for good reason, as he should be. The cops have testified that they wrote reports, and then the state says, oh, we don't have them. That's bullshit. Okay, lost police reports and Brady violations. Defense takes issue with several of Glanville's legal rulings, including, but not limited to, an overly liberal and unconstitutional application of OCGA, blah, blah. Most recently, Fulton County's district attorneys Hilton and Love took part in an ex parte meeting with Glanville. It also included these other people. Neither Stillwell nor undersigned counsel were informed. We know. Kendrick did his recusal on the 12th. Williams, through his attorney, has filed a motion for fair trial on July 10th. Williams' motion alleges and discusses several ways in which the trial has been unfair and has failed to meet constitutional requirements for Mr. Williams. Mr. Kendrick, through his attorney, has filed a similar motion on July 23rd. Stillwell adopts both motions and incorporates their contents into this motion, as Stillwell has been similarly affected by errors in this case. All right, so in regular people, that means the other motions that the defense attorney wrote, we agree with them, and you can consider them to be part of this motion, but we're not going to copy and paste. Okay. Here we go. Stillwell does not wish to demand a mistrial absent jeopardy attaching. Stillwell has been incarcerated since and has suffered through the duration of the case. Starting trial all over again is not a viable option for Stillwell. Furthermore, defense has completely neutralized all testimony and documentary evidence presented against Mr. Stillwell thus far. In other words, defense is winning this trial. Now, that's two lawyers who think the defense are winning, and they get to see the jury. So they have a better read on whether or not they're winning, right? And so Weinstein and Schardt believe that they're winning this case. That says a lot. Like, usually the defense is losing just by virtue of being defense. The defense is winning despite the persistent legal errors, Brady violations, ex parte meetings, and discovery issues that have plagued this case. Stillwell does not request to start this case over. Nonetheless, serious errors have tainted this trial and continue to prohibit Stillwell from receiving a fair trial and from confronting witnesses called against him. Stillwell's due process rights have been continued to be violated. These errors, described in detail in Williams and Kendrick's motion, have been caused by the Fulton County DA's office and Glanville, aka the government. These errors cannot be cured by curative instructions and will ultimately prevent these proceedings from meeting federal and state constitutional requirements, adhering to the Georgia rules of evidence, and fulfilling the requirements of Brady. Now, y'all, I don't know why this final paragraph was sent over here. I'm guessing maybe there was an orphan sentence and he just decided to move it, but I don't love that. But I also don't do orphan sentences, so, I mean, who knows. Wherefore, signed, blah, blah, blah. Certificate of service. Okay. Okay. So, Williams and Kendrick say mistrial and attach double jeopardy. Stillwell is saying, don't give me no mistrial. unless you're gonna attach double jeopardy. Otherwise, let's keep going, because I'm ahead. I'm winning here, so I don't want to start this shit over. Plus, my client's been in jail forever. Okay. Sorry, I just need a little break. I'm Lauren Cadillac, by the way, if you're just joining us, aka OG Cadillac, aka Mother of the Decade. I am coming to you live from Dallas, Texas, where I am an attorney. I practice in the courtroom. I am a litigation attorney. I mainly practice in the real estate arena, which is quite litigious. I would be happy to help anyone who's in Dallas and you need an attorney. Give us a call. Cadillac Law, 972-845-1200. Otherwise, for everyone else, I am recapping the YSL RICO trial, which I have been following from the beginning. And today we're going over all of the motions that were due on Tuesday, as well as some of the responses that are due today, the ones that are out. So thank you for being here. Thank you for everyone who has supported us. Make sure you hit like, make sure you hit subscribe. Thank you, Fatal Cherry. She sends me Cashapp. I really appreciate it very much. That helps me pay for these documents. And I got a better camera and a better computer. Thanks to you guys. So now you have a better view. I am doing great, and I appreciate all of you who are here this morning. Thank you so much. Now, we have the absolute best chat on the internet. There's no doubt. We have the most interesting, full of debate, and respectful chat. So thank you for joining that chat. I appreciate it. I will say that there are a lot of chats flying by, so unfortunately I can't see everything everyone's written. If you want me to be able to catch your attention, there is a way to do that with a super chat, I believe. So sorry about that. All right, here we go. Be more inspired. You just came back from Bryan, Texas. Oh, well, you were hot as hell. So you just came back from being incredibly hot. Congratulations. I'm headed to Canada on Tuesday, and I am going to be, the high is 75, y'all. So I am like, take me to heaven. Let's go. I told my daughter, and she said, can we live there? I don't know. I don't know about becoming a Canadian. I'm kind of a super proud American. I don't know if you noticed. But I dedicated my life to the laws of this country. My whole life has been dedicated. So I don't know that I could ever move to Canada. But you know what? I might be able to get a vacation home there someday. Okay. I will come live to you from Canada on Friday and hopefully have some footage of some trees. All right. I'm just glad I didn't have to write all these motions. I don't mind reading all the motions to you, but man, if I had to write all this shit, no. Okay, here we go. So this one again is from Max Schardt for his client Shannon Stillwell. This is a motion for reconsideration regarding certain hearsay statements. Copeland, a witness called by the state, is currently on the witness stand. Copeland has never claimed to have any first-hand knowledge regarding the death of Donovan Thomas. He did, however, meet with law enforcement several times in 2015. Oh, Army Nurse, thank you so much for the $5 super chat. I appreciate you. Thank you. And I have no problem reading legal language and interpreting it into normal person, and I'm happy to do it for y'all. So thank you so much for being here. Thank you for the super chat. Thank you all for your support. All right. On June 15th, in what was Copeland's 5th meeting with law enforcement in 2015, Copeland told him that he possessed specific information regarding the shooting death of Donovan Thomas. Copeland made this claim while under the threat of arrest for unrelated crimes that law enforcement was investigating. Copeland did not mention this information on any of the prior 4 meetings with law enforcement that year. Well, that's pretty significant, right? Like, all of a sudden, he's talking about this in his 5th meeting with the law. I'm not even trying to have one meeting with cops, if I'm honest with you. Ugh. In his June interview, Copeland told law enforcement that he picked up Deamonte and Garlington at a McDonald's restaurant on Cleveland Avenue in the evening of January 15th. Oh, that's why they kept talking about the McDonald's that used to be there. Okay. Copeland reported that Garlington walked to Copeland's car, and while the two men were briefly alone, Garlington told Copeland they killed Nut. Copeland told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that Stilwell, Kendrick'c, and Cobb and Demise McMullen were all present for and participated in a drive-by shooting of Donovan Thomas. Per Copeland, Demise McMullen entered his car shortly after Garlington, and all communication about the event ceased. Let me go see this footnote. It should be noted that Garlington is charged in this indictment. He was not severed from this trial as he remains unrepresented in the winter of 22. Garlington is not expected to testify as his case is still pending. All right. Copeland is now a sworn witness for the state and is currently on stand. On direct examination thus far, Copeland has not denied making this June 10th statement to law enforcement. He has repudiated the contents and veracity of his prior statements, however. He testified at trial that this conversation with Garlington never occurred, and he fabricated the event to get himself out of legal trouble. Furthermore, Copeland has denied contextual clues surrounding the out-of-court statement, testifying that it was Mr. Stilwell and not Mr. McMullen who got in the car with Copeland and Garlington that evening. So he doesn't even know who was in the car with him. Oh, by the way, 2015 was 9 years ago. By the way, 2015 was 9 years ago. I don't even remember what I did in 2015. Who was I in 2015? I have no idea. I think I was still working at AT&T. That's crazy. That's one thing that's really been bothersome about this trial to me is like how old this shit is. It is just so old and it just does not make sense to me. Stilwell has challenged the admissibility of Garlington's out-of-court statements on hearsay and confrontation. We talked about that in my hearsay video. Please go back and watch that. Glanville, who has since been recused from this case, ruled the statements were admissible as statements of a co-conspirator. This ruling does not comport with the Constitution. The plain text of the code requires that the proponent of evidence establish the existence of a conspiracy, show the statement was made during the pendency of the conspiracy, and the proponent must also establish the statement was made in furtherance of the conspiracy. Assuming Garlington actually said these things to Copeland, they were not made in furtherance of the conspiracy. To find otherwise simply overlooks and disregards the plain language of the law and the line of control in cases that establishes the statements that spill the beans, by definition, do not further a conspiracy. And then notice he cites 1, 2, 3, 4 cases. 4 cases. Not just, this is what I think it is. This is how it should be. This is my feelings. 4 cases say this is how it is, Judge. The law says this is how it is. This is what the code says. Here's what the cases say. Oh, I gotta tell you right now. The law does not give a shit about your feelings. Your feelings are meaningless under the law. Your feelings are not fact. How you feel about something does not matter at all. I have people come to my office, they want to talk to me about their feelings. You are at the wrong counselor. I am a counselor of the law. I am not a counselor of your feelings and mind. Okay? That's why I like real estate. You either wrote the deed and recorded it or you did not. Very, very simple. All right. Okay, Cherry, thank you so much for the $20 Cash App. You are such a great supporter of mine, and I really, truly appreciate you. Okay, thank you all. Everyone that supports me. You guys are awesome. The state plans to elicit testimony from Copeland regarding Garlington's alleged statements. While Copeland is now denying that Garlington made any such statements, Copeland has openly acknowledged he previously told law enforcement that Garlington made the statements. The state has attempted to improperly introduce the contents of Garlington's statement through recording of Copeland's prior statements, including his June 10th interview. The state's method is improper for 2 reasons. See, look, he has like actual reasons, and reasoning. First, Copeland has not denied making the prior statements, and therefore no foundation for prior inconsistent statements have been laid. Y'all go watch my impeachment video, okay? I talk about prior inconsistent statements and how to properly impeach a witness. Second, which is the focus of the motion, Garlington's statement to Copeland, even if uttered, were not made in the furtherance of the conspiracy and therefore fail to meet the requirements of the code. Pretty freaking easy. Pretty freaking easy. The code says it has to be these three things. This, and this. Not this, or this, and this. And the state can't just decide, oh, well, I got two. Okay, so let's get into the state. Now, I can't say enough how angry I would be if I were a taxpayer in Fulton County. Okay, I am angry as a taxpayer in Dallas County because I see a bunch of the BS they pull. I hear about the BS they pull and the waste of my money that they make on a daily basis, okay? But for Fulton County's DA to bring witnesses on about Donovan Nut Thomas, where the witnesses acknowledge that he was in a gang and he was a gang leader, and then to turn around and use tax dollars to write a motion to exclude victim character evidence, you get what you pay for, right? You get what you pay for. We don't pay a lot in taxes here in this country. We don't. Comparatively speaking, we're not paying a lot in taxes, but we are absolutely getting what we pay for. The state government that opened the door to the character evidence, that already outlined the man was in a gang and a gang leader, is now telling the judge that they think that the defense is going to talk about his character, and that should not be done. Oh, I'm sorry. I was just contemplating how upset I was about the tax dollars that were spent writing this ridiculous motion. Let's read it. The state believes defendants in the above style case may attempt to improperly place the character of the deceased victim, Donovan Thomas, as an issue of the trial. For reasons stated below, the state asked the court to prohibit any attempts by defendants to elicit and introduce improper character evidence. You know what my response to this would be? I would simply write, they opened the door. We have this saying in the law. They opened the door, so now I'm going to walk through it. The state opened the door to the character evidence when they had this dude's mom come on and talk about what a big bad gangster he was. I'm sorry. My eyes just rolled so hard it actually hurt my brain. I can't. I cannot. Ugh. Okay. Defendants Kendrick and Stillwell are charged in count 2 with the murder of Donovan Thomas, the overt acts 16 through 20 of count 1, conspiracy to violate racketeering, pertain to the murder of Donovan Thomas. They have pled not guilty. Okay. Georgia evidentiary statutes govern admissibility of a victim's character. They generally limit evidence of a victim's character to reputation or opinion and not specific bad acts. The law impertinent says evidence of a person's character or a trait of character shall not be admissible for the purpose of proving action in conformity therewith on a particular occasion. So that means that you're not going to give character evidence to show that that's the type of person that they are. So like, maybe someone has committed some fraud or something. You cannot show that fraud to show that they're a fraudster, but that they committed fraud in this case, right? But if you're in another case where you have a key witness and they have committed fraud, you can bring up their character issues, like you commit fraud, to show that they're not reliable. But you can't bring it up to show that they did this act. Okay. There are 3 enumerated exceptions: pertinent trait of character offered by a party to rebut the same, evidence of a victim's character for peacefulness to rebut evidence that the victim was an initial aggressor, and evidence of the character of a witness. Where evidence of the character of a witness or trait of a person is admissible, the proof shall be made by testimony as to reputation or by testimony in the form of opinion. So that's where you would get, Boleyn on the stand and say, yeah, Lauren, she's pretty nice sometimes, but she will flip her shit and has thrown a chair before. Right? So, if the case is that I threw a chair out the window and injured someone, they can bring Boleyn in, to say, yeah, she's thrown chairs before. We've seen her throw things when she gets mad. Now, I just made 100% of that up because I would never self-snitch. Generally, a murder victim's character is irrelevant and inadmissible. A victim's character may only be admitted if there exists some factual nexus to the conclusion for which it's being offered. It is impermissible to establish such a nexus through sheer speculation. Even in cases where an accused is arguing self-defense, the accused may only seek to introduce evidence of the victim's violent character through the admission of reputation and opinion testimony. Okay, so if you're saying, like, this person attacked me, it was self-defense, you can show evidence of the violent character of someone through reputation and opinion testimony. So, for instance, my mom was a child abuser, right? If she went and, beat a 10-year-old to death, they could call me and I could say, yeah, she hit her own kids, so of course she would hit some other 10-year-old. All right. No factual nexus to admissions of victim's character. The character of Donovan Thomas is irrelevant and inadmissible in this trial because there exists no factual nexus for introducing any evidence pertaining to his character. Furthermore, any evidence of the victim's violent character is unequivocally irrelevant because no defendant has claimed self-defense. Finally, if the court were to find a relevant purpose for victim character evidence, it could only permit admission through reputation and opinion testimony, not specific acts. Is that even a good motion? Like, is that even well written? No, it's not. It's terrible. I'll answer my own question. No, it's crap. It's total crap. Total crap. As is the next motion I'm about to read to you. Okay. Are any of you old enough to remember the O.J. Simpson trial? Oh, how about the Scott Peterson trial? Any of you old enough to remember Scott Peterson trial? Well, if you recall, Scott Peterson had a mistress, and his mistress hired Gloria Allred, I think is how you say it, to be her attorney. Allred? Anyhow, Gloria was all over the news presenting a case of public opinion about her client who was Scott Peterson's mistress. My entire life, I have always seen defense attorneys all over the news answering questions, trying to bolster the reputation of their client, trying to bolster their client's innocence. I have never in my entire life seen the government restrict such behavior. I just haven't. Okay, a bunch of you remember these trials. Okay, a bunch of you remember this. So then y'all remember the lawyers being on TV, right? Like, this is back when we only had 4 or 5 channels, unless we paid for cable or whatever. We saw them on TV, right? And they were talking about their client, and they would maintain that their client's innocent. I think Karen Reed's lawyer went on Dateline and did the same thing. Okay. We have a First Amendment right to free speech in this country, all right? Now, of course, attorneys and their clients have privilege, and attorneys should not breach that privilege. even if they're out there trying to defend their client's reputation or whatever it might be. Okay? Fine. Attorney-client privilege, don't want to breach privilege. Again, sorry, my eyes are just rolling so hard every time I think of what this government is doing. Miss Love went ahead and took God knows how many hours of taxpayer dollars and wrote this. State's motion to restrict extrajudicial statements. Are you freaking kidding me? Are you freaking kidding me? I want my money back. I don't even pay taxes in Fulton County. I want my money back. I hope some of you are watching our voters in Fulton County and you vote accordingly, because this is your money. I would never, if I have clients, my clients pay me with their hard-earned money, so I actually think about what I'm going to file, okay? I would never file some shit like this. Hey, Frederick. Hey, everyone that's late. Make sure y'all please hit like, okay? Please hit like. If you haven't subscribed, do that. I'm trying to get to 10,000 by the end of the year. I want my cute little plaque. I also like showing my kids that I'm really cool, and your likes and your subscribes show that, and then I can show them, oh, look, I have members. I have members in my, people pay to be able to, like, hang out with me, guys. I'm that cool. Please help me. All right. I was going to say waste of trees, but we don't actually print these things anymore. This was just a waste of time and money, and here it is. Now comes the state of Georgia and moves the court, instruct the defense to refrain from making further extrajudicial statements about this case moving forward. I gotta stop. I'm sorry. Hold on. I'm sorry. A grown woman just tattled. A grown woman just ran to mommy and said, Mommy, he's talking mean about me. I'm sorry. It takes me a moment to process this juvenile bullshit. Okay. Okay, here we go. Mommy, I'm telling. Georgia Rule of Professional Conduct 3.6 prohibits lawyers for participating in litigation from making extrajudicial statements a reasonable person would, quote, believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. A relevant factor in determining prejudice is the nature of the proceeding involved, with criminal juries' trials being the most sensitive to extrajudicial speech, the character, credibility, reputation of a party, and any opinions as to the guilt of innocence of a defendant are subjects deemed to be more likely to have a material prejudicial effect on a criminal proceeding. Okay, well, she did cite some law, at least. She cited one law. Let me see. Defense counsel have made numerous extrajudicial statements explicitly about this case while a jury is sworn and seated during the state's case in chief. They do that all the time. Like, you see them leaving the courthouse with their clients. These people can't leave the courthouse with their clients because their clients are being unreasonably held. But usually you see they come out, yeah, it was a good day in court today. We'll see you tomorrow. Here comes the tattle. Defendant Williams' counsel Steele and Keith Adams and Kendrick'c counsel Doug Weinstein and Stilwell's counsel Schardt have all made extrajudicial statements to the media. Ooh. I just can't. I can't. The extrajudicial statements have included, among other things, interviews and statements to the Associated Press, 4 of those interviews have been 25, 33, 43, and 107 minutes of length. This emotion screams to me. This emotion screams to me. I don't like that the media likes these defense attorneys. I don't like that the media is criticizing my work. I don't like that the media won't interview me. That's what this says. Pursuant to the OCGA, the courts have power to control the furtherance of justice, and we asked that the defense not make extrajudicial. I'm going to get this code of conduct. Rule of professional conduct. Conduct 3.6. Right? 3.6? Hold. 3.6. Okay, let's look at it. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements that a person would reasonably believe to be disseminated by means of public communication if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph may be limited to such information is necessary to mitigate the recent adverse publicity. No lawyer associated in a firm or government entity with a lawyer shall be subject to A shall make a statement prohibited by A. This is the statement that is going to be prejudicial. Jeffrey Williams is innocent of charges brought in this indictment, and to clear his name, he sought a speedy trial, one in which he would receive constitutional guarantees of a fair trial with an impartial judge presiding and ethical prosecutors following the law. Sadly, Glanville and the prosecutors have run afoul of their duties under the law. Williams is grateful that the reviewing court agreed with him and entered the order recusing and disqualifying Glanville from presiding over Williams' case. We look forward to proceeding with a trial judge who will fairly and faithfully follow the law. How the hell is that going to have a substantial likelihood of materially prejudicing the matter? Here's Keith Adams' interview. I didn't watch. Oh, and look, she even puts oh, judge, go to these. She says how long it took. Here's the Associated Press, says they reached out to Glanville and a lawyer for Thug. Fannie Willis's office didn't respond. While I respect Chief Glanville and his service to the community and the country, he simply became biased over the course of the case, Kendrick's lawyer Weinstein said. He added that he looks forward to trying the case before an unbiased judge, but said the only outcome at this point is a mistrial and bond for Kendrick, who has been jailed for more than 2 years. Okay, this is where Weinstein met with Megan Cuniff. I watched parts of this. Nothing seemed even remotely off. Here she interviews Max Schardt. I watched parts of this. This is where we learned that that Shaquille Kokomo is Schardt's Boleyn. Shaquille Kokomo is to Max Schardt as Boleyn is to Lauren. All right, that's where we learned this. Here's Doug Weinstein in another interview. I mean, you tell me what you think. Y'all tell me what you think. We know that Adrienne Love is obsessed with Brian Steele. We already know that because she talks about him every time she gets a chance. She's obsessed with what he's doing. She's obsessed with how he practices. She's obsessed with him. Now we can see that part of her obsession is the media attention that's been given to the defense. But guess what? The state never gets to go talk about their case. The state doesn't get to, that's not how it works. If she wants the limelight, she can become a defense attorney. It's really easy. Just go defend people. She couldn't do that though, because she couldn't win if she actually had to, like, you know, do a job. She can't do her actual job, please. Please. Oh my God, you guys are so many. Oh, I just feel like I've been talking nonstop. Like, don't you get tired of my voice? Ooh, shoot. Okay. All right. Veronica reminds us, Steele at one point said, I don't care about Miss Love and her objections. And if you recall me talking about that when it happened, it made me feel better because I always talk about, I don't care about that. And then I'm like, am I a bad person? And then I'm like, no, I'm just a lawyer. Which some of you might think is actually makes me a bad person. I don't know. Okay. Now, the next motion I'm going to read comes from YSL Ponytail, aka Bruce Harvey, aka the creator of the Harvey Rule, aka the baddest mofo in the room, aka the person that Glanville would shut up and actually listen to. Okay, so let's go into that. And can I? Yes, I can zoom. Guys, I gotta zoom. Like, if you're watching this on your phone, you need to be able to see these things, right? All right, here we go. Now, this is Quamarvius Nichols. Motion for mistrial and objection to mid-trial substitution of the judge. I love this. I love it. It's the, okay, hold on. Before I get into it, this is why you don't want to have 6 defendants with 6 different lawyers. When I saw that they are doing all these defendants together, I said, who is the idiot that did this shit? It is hard enough to go against one defendant and one lawyer. You do not want 6 people coming against you. And this is why, because 4 of them might all have the same point of view and see things the same way, but there's always going to be someone who sees things totally different and comes from left field. Like our man here, Bruce Harvey. All right, here we go. Okay, comes now, Nichols by and through counsel and files this. Nichols adopts all motions and arguments for mistrial as filed by co-defendants. If such motions are denied, he further moves for mistrial and objects to mid-trial substitution for the following. All right, so what that says is all those motions for mistrial, Williams, Kendrick, the Schardt one we just read, all those I'm incorporating. I agree with them. Those, you can take those as my words too. But if you won't rule under what they've already presented, here's my other idea of why you should mistrial. I love it. Nichols moves for mistrial and objects to mid-trial substitution of judge because here, for a judge to be substituted after 19 months of trial, including 6 months of testimony and the admissions of evidence, prejudices the defendant's right to a fair trial under the 6th and 14th Amendments, as well as the concomitant provisions of the Georgia Constitution. Further, Nichols moves for mistrial and objects to mid-trial substitution of the judge because the current presiding judge was not the judge during the last 19 months of trial. When, for example, Nichols moves for a directed verdict, okay, I'm going to pause right there. I talked to you, I think, briefly about what a directed verdict is, but when the state rests their case, the defense is going to move for a directed verdict. Basically, you're saying, Judge, the state just finished their case. They did not prove it beyond a reasonable doubt. I don't have to show my case. This is over. Give us the verdict. I got one of those one time, dude. One time. The fact that I even did it once in my career is like such a big deal. Okay? So, Here we go. The court will be unable to adequately evaluate the entirety of prior proceedings in order to rule upon the request. This is true. Even if the new court read every single word of every bit of the transcript, there's still so much nuance that occurs in body language, movement, all these things. There's no way the court is going to be able to make a ruling on all the crap that's happened in the last 19 months. Of the 19 months of trial, 6 months have been testimony for which this court was not present and therefore cannot base its decision on what has occurred during trial. Additionally, Nichols moves for mistrial and objects to mid-trial substitution of trial judge because on Friday, July 18th, this court advised the parties that she was unfamiliar with the previous trial proceedings that have occurred over the last year and a half. During the trial, before this court became presiding judge, Glanville made several contingent decisions, noting that he would revisit his rulings as trial proceeded. Now, I don't know if you guys remember this, but that was something that really irritated me about Glanville. He would never just make the damn decision. He would go, okay, well, I'll do this later. And we have judges here in Dallas that do that. They're civil judges, not criminal judges, but they will put shit off. I mean, I talked to a lawyer the other day. He finished a trial 2 years ago. He still doesn't have a signed order. He had a whole trial, and he won in the trial. There's still no signed order. The judge's plenary power has expired. It's ridiculous. So that happens, and that is so incredibly frustrating. And the point that Bruce Harvey is making here is, look, we already made all these arguments. The judge reserved his ruling. You can't make the ruling because you didn't hear our arguments. These contingent rulings cover several aspects of tentatively admissibility of evidence. Given the fact that the current court is unfamiliar with over 6 months' worth of testimony, arguments by the parties, motions by the parties, and contingent rulings, this court would not possibly make decisions based on what has occurred, which the court was not privy to nor has reviewed in the record. Nicholas further moves for mistrial and objections to mid-trial substitution because he specifically, on several occasions during the trial, moved for the court to give curative Rule 105 instructions. The court denied each request to give such an instruction at the time, but indicated it may be necessary to give at a later time or at the end of trial. Nichols moved the court for severance on multiple occasions, which the court denied at the time, but agreed that a time may come that the issue would be revisited. This court would now need the benefit of 6 months' worth of previous testimony to adequately and fairly make decisions regarding whether an instruction or a severance is warranted. Okay, so this was my big thing. When Glanville was recused, my biggest question was, how are they going to put together jury charges? Because Glanville has agreed to all different little instructions in the jury charges that she doesn't know about. So how the hell is the new judge going to write the jury charges with these lawyers if she doesn't know about this stuff? Given the court is unfamiliar with the trial proceedings, as it has indicated that it did not intend on familiarizing itself with the trial proceedings, Nichols' constitutional rights are violated because this court cannot make informed rulings based on the record. Trials evolve and decisions are made by the court based in part on the way the trial and evidence plays out over time. And this court has missed crucial proceedings necessary to make a fair and well-rounded rulings and to properly instruct the jury both during and at the conclusion of trial. Ain't that the truth? Nichols moves for mistrial and objects to mid-trial substitution of the trial judge because this court has indicated that it does not intend on reviewing the complete record, including trial proceedings and litigation that have already occurred. For this court to step into a 19-month ongoing trial in which over 100 witnesses have already testified means that this court is proceeding with trial and unable to assess core trial functions such as the credibility of the witnesses that have already testified. The lack of a trial court being personally familiar with the record but presiding over the continuation of the trial, making decisions regarding the trial, and instructing the jury violates his right to due process and a fair trial guaranteed by the Constitution. Nichols further moves for mistrial and objects to mid-trial substitution because even if this court attempted to read the transcripts of the past 6 months' worth of trial, that would not be an adequate substitute for the court observing live testimony. Exactly. This is what I've been saying. Like, even if you read the transcript, there's so much you miss if you're not in person. Even us, we've been watching this. We have missed so much because we're not physically there. Even if this court attempted to watch 6 months of trial proceedings via media recordings from afar, that would not be adequate substitute for the court's personal and direct observations. That's literally what I just said. If there was an argument to the contrary, Nichols notes that the media was not allowed to film several witnesses and at times were not recording due to technical difficulties. Mic drop. Nichols moves for mistrial and objects because the trial has been suspended for over a month and jurors cannot reasonably be expected to just pick up where they left off with their memories and observations intact. This is what I've been saying the whole time. Furthermore, a mid-trial substituted judge cannot adequately instruct the jury regarding previous proceedings which the judge is unfamiliar with. Finally, Nichols reiterates and realleges his request for severance and incorporates his previous arguments that an enormous amount of prejudicial spillover has already occurred and no jury could be expected to compartmentalize the evidence as it relates to the separate defendants. You know, I'm just excited to see like the ideas that I was having are like Bruce Harvey had those ideas, because I feel like that means that I'm a good lawyer. Because I know he's a good lawyer, right? So if he and I were like on the same page, then I'm like, okay, good. My mind's in the right spot. Even though I really don't do criminal defense. Okay. Tall Glass says the outfit issue. I can tell you the outfit issue. They only need 5 outfits a week, and on Friday the outfits should be taken home. New outfits returned on Monday. That's the issue. The bailiffs did not want to be in charge of all those outfits. I guess it was like a whole room full of outfits. Which is kind of funny. All right, everyone, I'm going to take a quick break. I am lcadilac. I am an attorney in Dallas, Texas. I love watching trials. They help me learn how to do my job. They help me be a better lawyer. I have been following the YSL trial for 19 months, as it turns out. And we're here going over the motions that were due on Tuesday, as well as some of the responses that came out today. And Veronica, you're right. If the judge grants them bond, then the outfit thing is no longer an issue. The only reason the bailiffs are in charge of the outfits is because they're in jail. The men are in jail, and they're not allowed to have regular outfits in jail. Okay. All right. Here we go. Renewed motion for bond and brief in support of pre-verdict bond. Okay, get some water. Make sure y'all are hitting like and subscribe. I hate having to beg, but I'm going to. Please hit like, hit subscribe. Help me show my children that I'm cool. Oh, those outfits, these like Gucci suits and stuff. These bailiffs do not want to have charge of these clothes. Like if someone steals them, they're on the hook. They don't want that. I wouldn't want it either. Y'all can have 5 outfits a week. We don't need to have a whole wardrobe back here. Okay, please. All right. Make sure you hit like. Make sure you subscribe. Thank you if you've contributed funds. Thank you for you who Cashapp. Thank you for super chats. Thank you for being here. Thank you for listening to my voice. Let's go. This is the renewed motion for bond and brief in support of pre-verdict bond. This one is done by Jeffrey Williams. In the great state of Georgia, notice great and state are capitalized. We talked about this, guys. The capitalization matters. Like, these are things that lawyers know, right? And so we know if he puts great state in lowercase, he's dissing the state. That's why he put lawyer love in lowercase. All right. Unlike other states, for purpose of pretrial bond analysis, the presumption of innocence remains with the person accused of an offense, even a capital offense, from arrest and even during trial. So, in this country, we are presumed innocent until the government has done their job of proving beyond a reasonable doubt that we are in fact guilty. And so this citation of case law tells us that in Georgia, that presumption of innocence carries through the trial. That means prior to and during trial, courts view criminally accused to be innocent of the charges waged against them. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecution proves guilt beyond a reasonable doubt. And here he cites some other stuff. These are not Brian Steele's words. These are words of legal professionals from before him. Thus, the granting of reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence secured only after centuries of struggle would lose its meaning. Okay. This is like, I have had family serve in the military. I have family who died serving in the military. They did that so that we could be presumed innocent if we were ever charged with a crime by the government. That's what makes America great. That is why America is rad. Okay. In order to protect our firm foundational belief in the accused is presumed to be innocent prior to a finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing the court there are no set of conditions or circumstances that can be ordered to permit pretrial release. Okay, so the state has to prove to the court that they should not be released on bond. That explains why it was so easy for Love to get Glanville to not release them on bond, because as we know, Love is doing work in a courtroom where everything she asked for is given to her. All right, she didn't actually have to work to do her job. Okay. This requires prosecution to carry the burden of proving by a preponderance of the evidence. I do believe I've talked about the legal burdens. I know I talked about reasonable doubt. Preponderance of the evidence is like more likely than not. So it's a standard in civil law. This is the standard that I usually am forced to prove my cases. I don't have to prove beyond a reasonable doubt. I just have to prove that more likely than not it occurred. So in this case, the state has to show more likely than not that there's a flight risk or some kind of risk in allowing Williams to be out on bail. Okay? It is so significant to deny Williams pre-verdict bond that the Supreme Court of Georgia requires this court to specifically explain why no bond should be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. And he cites the law. He didn't make up flagrant abuse of discretion. This is what the law says in Georgia. Case law says that the judge, there must specifically explain why there's no bond because of the concern of flagrant abuse of discretion. When considering pre-verdict bond, alleged guilt is extraneous and completely irrelevant and not considered for pre-verdict bond analysis, as supposed guilt has no place in the bail proceedings. Again, cites the law. Our highest court explained that in a bond hearing, Williams bears the initial burden of producing evidence that he's not a flight risk, that he's not a danger to the community, he's not going to commit a felony while on bond, and he's not going to intimidate witnesses. Cites the law. Look at this. I love it. Full of case law. Williams is not a flight risk. First, he must show roots in the community, which include the length and character of residence, employment status, and past history of responding to legal proceedings. He was born and raised in Jonesboro South, and since his birth in August of '91, he's maintained a residence in Atlanta. He's traveled the globe and performed his music in every continent except for Antarctica. He always returns to his home in Georgia. In fact, days before the return of the original indictment and the arrest of Williams, he returned to Georgia from the country of Norway. He is one of 11 children and the father of 6 children, ages 6, 13, 12, 11, 9, and 9. Oh, he had 2 babies in the same year. Ooh, oops. All of Williams' family lives in Atlanta area, including his parents. There's not many among us who have stronger roots in the community than Williams. He's been working since he was 6. At the age 14, he was recognized and began performing his music. As a teenager, he had a manager, and within a few years, he was signed by Atlantic Records and paid $1 million. He's currently gainfully employed, tirelessly working at his artistry and other lawful businesses that include clothing lines, modeling, owner of a successful record label, and various investments. Mr. Williams has demonstrated a strong history of legal employment. I feel like all this has already been put out there, but Glanville was just an extension of the prosecution. So now you have to go argue this to the new judge, who is hopefully not an extension of the prosecution. Okay. Mr. Williams has appeared in courts in the past, represented by undersigned counsel for approximately a decade, to wit, his entire adult life. He has never missed nor been late for a court appearance. He has a history of responding to the legal process. Undersigned counsel is in possession of his passport and has permission to surrender his passport directly as directed by this court for purposes of bond. So sometimes if they think people are flight risks, they'll just have them turn over their passport. I mean, we've heard that. If you've watched Law & Order, you've heard that before, okay? So here you are. Here's Law & Order in real life. Furthermore, when a bonding company writes a bond for the criminally accused, that company takes financial risk in ensuring the criminally accused present in the court. In the case at bar, free at least last bonding are motivated to keep track of Mr. Williams and prevent any possible flight. Citing case law again. This whole document has just been case law, case law. This is what you expect to see from a lawyer. This is how they teach you to write in law school. Not just, give me what I want. Williams intends to present witnesses to testify at the renewed bond hearing. Specifically, his parents, managers, and members of his record label, childhood friends, business associates, and the like will be present in court to testify and show support for the granting of pre-verdict bond. It says here he respectfully requests a date certain to argue this motion for bond so that out-of-state witness can be present. He's not a significant threat to the community. He's taken initiative to secure the commitment of full-time, off-duty sworn law enforcement officers to watch his home and secure his home 24 hours if house arrest is ordered by the court as a condition of bond. He will also submit to wearing an ankle monitor. He will submit to a condition that any person who would visit him at his abode would have to be on an approved list. Okay. And the individual's name is not on the list. The person will be denied entry to his home. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer, and if the visitor does not agree to consent in the search, the person will be prohibited from visiting with Mr. Williams. He agrees that any of his text messages, telephone calls, or other form of communication can be secured and information provided to the court if desired. So basically, let me stay in my house. I'll have the cops watch me 24/7. I'll give you every text message I make. I'll give you every communication I make, and you could see that I will be a good boy. With these parameters in mind, it cannot be said that Williams would be a threat or danger to the community or any person or property in the community. Undersigned counsel will agree to meet him at his home to prepare for trial. The above conditions place William in custody in his home. Cited a case. This case he's citing must say that when you are on house arrest, you are in custody just at home. Citing cases, case law. Specifically, our General Assembly has provided for creation of electronic pre-verdict releases to assist sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish purposes. Therefore, General Assembly explicitly recognized Williams' home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond, and he cites another case. Ordering Williams to wear an ankle monitor and to be in total lockdown in his home is the equivalent of custody and confinement and has been deemed lawful without punishment imposed by the current county jail conditions wrongfully imposed. Since May, Williams endures the torturous conditions in the county jail. 22 out of 24 hours a day locked in a small cell with no contact, except when his counsel visits and in court proceeding, inedible food, living in squalor, ant-infested room, and unable to see any activity outside the cell's windows. I'm surprised he didn't talk about the light. Maybe they started turning off the lights for him. Like, maybe they turn off the lights for him now at night, so he's not just sitting in light, because that was actual torture, like barred by the Geneva Convention. Williams is not a convicted felon. This fact alone satisfies bond factor. Moreover, law enforcement officers executed a search warrant on May 29th after the arrest, and drugs and guns were allegedly located in his home. At the time of the search, there were numerous people at his home. This because others live at his home more often than him, because he's only there home intermittently. He has several homes in the Atlanta area. He is not a significant risk to commit felony while on bond, especially with the use of security and other conditions offered above. Again, citing case law. Mr. Williams has suggested as condition of bond that all of his calls, text message, and other means of communication are to be monitored, save privileged communications. Additionally, he will secure in his home when not present in court. This will prevent the possibility to intimidate a witness or otherwise obstruct the administration of justice. Ironically, the judge and the state, the prosecution, have intimidated a witness. They have intimidated. We read the transcript. And Steele's saying, my client's not going to do that. This court's foremost consideration with fixing the amount of bail should be the probability that Williams, if granted bond, will appear at trial, again citing another case. Williams is a respected high-profile artist who has positively impacted the lives of others who would otherwise never break the poverty line. He's made tremendous positive impact in our community. He's a positive member of society, and he will continue to lawfully and ethically fight these baseless charges. Governed by the above facts, he satisfies all four prongs of IOLA. Now the burden shifts to the prosecution. They retain the burden of persuasion that there are no conditions of bond that can be crafted to permit him to be entitled to a pre-verdict release whatsoever. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. Cites another case. Indeed, the most important element of liberty is to be free from physical detention by one's own government. Cites another case. You can see the difference, right? You can see the difference between Brian Steele and citing the law and citing cases, and Adrienne Love in her motions that basically say, give me what I want, because I want it. Okay, I have a minor issue in that I do not have a copy of Brian Steele's motion about correcting the evidence. I don't know. I don't have that motion. Let me check, see if Bullen emailed it to me. I know that Brian Steele wrote a motion where he asked, or he reviewed the he reviewed the spreadsheet provided by, I guess, the court reporter and the state about evidence that has already been admitted. However, it turns out the state failed to submit quite a bit of evidence. And I'm talking quite a bit. And then there's evidence on the list that's not actually admitted. So a list of evidence was provided that included evidence that didn't actually get in. So the list said this evidence is in, but it wasn't actually in. It wasn't actually in. Let's see if I can find it. So here's the deal. During trial, most attorneys keep a list. Like, I personally will have a witness and evidence list, okay? And then I keep that, and then I kind of check off along that list, admitted, denied, da-da-da-da-da. A lot of folks will put a list like that together for the judge and have columns, you know, admitted, denied. There's one judge that I do that with, but not all. Let me see if I've got... can't find it. Hold on. Oh, here we go. Facts on it. Thugger Daily, if y'all are on... Oh, oops, no. If y'all are on Twitter, there is a Thugger Daily, and he writes, he provides copies of these motions, okay? A lot of times. Which y'all should support him, because these are very, very expensive. Because we have to buy them. You have to pay for them. This stuff is supposed to be, free, but it's not. Okay, I don't know why I don't have it, but I do have, wait, let's see, hold on. Okay, let's just go to these state motions, and they're responding to the defense motions, so we should be able to understand what the defense says in these. I know, I don't know why I can't find it. Oh man, Tallglass says that the Brian Steele's footnote says there's over 100 instances of evidence that was not admitted that the state is saying is admitted. That's freaking crazy. That is freaking crazy. If Belinda's on, she can send it. She'll email it to me. She'll let me know. In the meantime, well, actually, while I wait for Belinda to search for that for me and email me, let's go to Kendrick'c opposition to the state's motion to restrict extrajudicial statements. Okay, so if you recall, about 15 to 20 minutes ago, I went on a tangent about how the government has wasted money, and one of those wastings, in my opinion, was asking to restrict extrajudicial motions. You may also recall that I too love starting things with a quote. So we're going to go right into Weinstein, and we're going to go straight to his quote. Everyone is in favor of free speech. Hardly a day passes without its being extolled, but some people's idea of it is that they are free to say what they like, but if anyone says anything back, that's an outrage. Sir Winston Churchill. What a perfectly fitting quote. What a perfectly fitting quote. My God, Churchill, it's like he foresaw this or something. It's wild. Oh my goodness. Some people's idea is that they're free to say what they like, but if anyone says anything back, that's an outrage. If that does not exactly address Miss Love's wham wham mommy, they're going to the press motion, I don't know what does. I mean, that is the perfect quote for the situation. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then decide to brag on it, which you do that for a form of intimidation and further the gain not to be held responsible. The Honorable Fannie Willis, Fulton County DA, press conference, August 29, 2022. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. I'm sorry, I gotta stop. It's beautiful. Free speech for me, but not for thee. He quotes Winston Churchill and then goes straight into quoting Fannie Willis. Oh my God. Oh. I think maybe I just decided that YSL Weinstein is actually the best lawyer. I swear. I mean, but he's in company with Harvey and Steele. I don't know. These are some phenomenal attorneys. I just love this. I love this. I'm glad I did this one first. And Boleyn, if you're looking, please try to help me find the Steele one. Thank you. Okay. Oh God, I just freaking love this. I love it. This should not be surprising to anyone. Oh, fuck. Sorry, it's just getting even better. It's so good. It's so good. It's so good. Oh my God, it is so good. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite this court's order that such a showing be demonstrated prior to blocking the broadcasting of witness testimony. After attacking the integrity of respected counsels for defendants and witnesses, e.g., repeatedly calling the Honorable Brian Steele a liar and accusing the Honorable Jonathan Melnick of working for defendants rather than his client Kenneth Copeland, the state now turns its attention to counsel for Deamonte Kendrick'c. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think it's hell. Oh my God. Citing President Truman? I swear to, oh my God. This is a work of art, y'all. Oh my God. To paraphrase, he's saying we're doing our job and the state is pissed. The state doesn't like it. Wow. In a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry-picks certain comments to the rule to support its motion to instruct the defense to refrain from making extrajudicial statements about this case moving forward. No case law is cited. What did I say? What have I been saying all fucking day this morning? All day with y'all. What have I been saying? No case law cited. No finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows reasonably should know have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick'c counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick'c counsel that might arguably violate Rule 3.6. The court should decline this invitation. I'm actually a little bit jealous, honestly, because I don't think I write this well. This is so good. I don't think I've ever written anything this good. That makes me sad. I wish I was this cool, honestly. You know how I could feel cooler is if y'all were liking and subscribing. Then I could at least impress my children. Remarkably, the state does not make a single argument that any statement by Kendrick'c counsel meets any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement made by Kendrick'c counsel was known or should have been known to have a substantial likelihood of materially prejudicing the jury. No argument was made because no argument can be made. The present jury had been impaneled and hearing testimony for months before any statement was made. The jury has been instructed at the conclusion of every day of trial by Glanville through his ad nauseum admonitions not to discuss the case with others or with each other. They have been instructed daily not to consume any media about the present case. No statements by counsel for defendants can be heard by the jury to prejudice the jury. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses, to wade through hundreds of minutes of interviews, find statements of Kendrick'c counsel that it's supposed to say be objectionable, determine that Kendrick'c counsel knew or should have known, and summon a reason about why and how they could materially prejudice a jury that is barred from and admonished on a daily basis from consuming media about the present case. This honorable court should respectfully decline this invitation. In addition, the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6. Okay, so there are a lot of lawyers. Now, see here, this is the thing too. We owe a duty of candor to the court. So what that means is if there is case law that goes against what our client wants or what our point of view is, we have to admit that. We have to be open with the court. So when you're quoting a law, right, if there is an exception enumerated or there's some kind of comment like this that goes against what you're arguing for, you still have to tell the court about it. We have a duty of candor. So the prosecution has to use the full word in all the comments. And Weinstein is saying they didn't. Let's see how. Comments included in 3.6 that prevent Kendrick'c counsel to speak to public on its behalf. 5BA reads, there are certain subjects which are more likely than not to have no material prejudicial effect on a proceeding. Excuse me, I got the hiccups. Thus, a lawyer may usually state information contained in a public record. Each statement made by Kendrick'c counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks intended to demonstrate that Kendrick'c should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick'c and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. What did we talk about earlier? This is what lawyers do. Defense lawyers go out and protect and support the reputation of their client. Kennedy also correctly notes that the police, the prosecution, other governmental officials, and the community at large hold innumerable avenues for dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. And most criminal defendants have insufficient means to retain public relations teams apart from defense counsel for the sole purpose of countering prosecution statements. Kennedy Kennedy cites the important role that defense counsel plays in educating the public on pending cases. Because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Hello, that's why you guys are watching me. Hello, that's why YouTube has a zillion lawyers on it. Because we understand this crap. Because we went to school for it. Because we took a bar exam about it. Because we participate in it. Since lawyers are considered credible in regard to pending litigation in which they are engaged, and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. Wow. This is a perfect... Weinstein is so good at finding quotes, y'all. I need my fan. Woo. This is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who's an artist. He writes, records, and performs rap music. In Fulton County, this makes him a target of the state. He is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a PR firm. Having smeared Kendrick and his reputation, the state wants to silence him. Initially, by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him, and now by holding a press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Ooh. Oh my goodness. Oh my goodness. Oh my goodness, y'all. Now, compare that response to the 1.5-page motion that didn't say anything in it. Who's the better lawyer? But again, y'all, we get what we pay for. We don't pay a lot of taxes in this country, so we're not exactly getting the best people working for the government. We fund the people to work for the government through our tax dollars, and we don't pay much in taxes. We kind of founded our whole country on a hatred for taxes. We kind of founded our whole reality on taxes are bad, and therefore we are not actually paying for the services, and therefore we cannot receive the services. You're going to get what the money can buy. Okay? All right. I haven't heard from Boleyn. I haven't found the motion yet from Steele, so I'll hop into this other motion. This was filed this morning at 10:13 their time. All right. The state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. Okay, so I don't know what that motion is. State's ruling, response in opposition to defendant's motion for correct ruling on adoptive admissions. Okay. State's response in opposing defendant's motion for correct ruling on self-serving hearsay. State's response to defendant's motion in opposition for correct ruling on vague questions. And state's response in opposition to defendant Williams' motion to challenge factual findings. Okay, so this is the one that has to do with the Krause this has to do with the Krause order, so we'll do this one first, okay? This is the motion. The government is responding to YSL Steele's motion to correct the Krause order, where she calls it hyperbole. I thought we already read this. Oh no, remember, the state already wrote a response in opposition. And if you recall, it only had like 2 things in it and no law. So maybe they went back and realized that maybe the state went back and realized that they failed to, actually cite any law or actually cite any cases. And so maybe they wanted to make this more robust. Boleyn, you are looking for a motion in opposition a motion for correct rulings on vague questions, a motion for correct rulings on self-serving hearsay, a motion for correct rulings on adopted omissions, and a motion for correct ruling on assuming facts not in evidence, which I'm guessing are all in the same motion. I know Steele presented a motion that listed evidence. The state has sent evidence in a spreadsheet, and Steele wrote a motion and said this evidence isn't actually in the record. So, Boleyn, just go into that e-file and see what you got. See what you can see Steele has done, please. Okay. So, the state already did a response, but I guess they decided, since it was so crappy, maybe they'll do a new one, because this one came Tuesday, so I don't know. Maybe they enhanced it. All right. Okay, they filed their motion. Legal authority 24 governs the requirements for recusal, and you must do it on the affidavits. The judge, considering on the merits of the motions, must find. Wait. The rule requires the judge considering the motion to recuse, rule on the merits of the motion, and make written findings and conclusions. Okay. Krause considered the motions and the affidavits. When a motion to recuse has no merit, a judge is perceived we already read this. Lack of authority. Yeah, okay, we already read this. So they didn't write a new one. I just had it open twice. Sorry about that, guys. Okay, so, I have been talking for 2.5 hours, and I need a comfort break. So I will return in a minute. Okay, sorry about that. Girl had to go on a comfort break. Gotta double tap. Okay. Whew. Sorry about that, y'all. Woof! That coffee really is like coffee. I'm kind of glad that I drank it though, because man, I've been talking for 2.5 hours. Woof, woof, woof. The crack coffee. Okay. You know, usually I'm playing video, and I'll put the video on the full screen, and I'll run to do the cover break. And so you guys never even know. But today, I gotta read all this BS to you out loud, and so obviously, when I need my little break, you're gonna know about it. So sorry about that, but here we are. Okay, I don't have the Steele motions yet. Boleyn is diligently searching for them for y'all. That's how much we love doing this. Okay, so she's doing that. She's gonna find them. In the interim, we're gonna look at these state motions in response that they filed this morning, and we should be able to figure out a little of what's going on, hopefully, based on their response. Whew, okay. It's so many damn words, y'all. Williams moved to vacate, precluding cross-examination question. Oh, wait. Vacate proper rulings on state objections, precluding cross-examination questions, which assume facts not in evidence. Williams does not include a request for specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. The court should correctly sustain state's objections to questions assuming facts not in evidence. Williams' motion should be denied. Okay, hold on. Before I get too deep in that, let me just tell you what I think is going to happen on Tuesday. The first motions that should be heard on Tuesday are the mistrial motions. I believe the judge will allow each attorney that filed a mistrial motion to get up and argue their mistrial motion, and then allow the state to counter. Okay. I believe that if the judge follows the law, she will in fact declare a mistrial. Whether or not she'll say double jeopardy attaches is a totally different issue. I am not sure about that. But I do believe if you follow the letter of the law, a mistrial is warranted. Okay. If that is the case, then all of these documents I've just read to you after the mistrials are moot. They don't have an issue anymore. If she calls a mistrial, the trial's over. So there will be no reason to even review these documents. There would be no reason for these to be argued. There'd be no reason for Steele's motion about evidence to be argued. None of that would be necessary. Okay. However, that being said, my experience with Fulton County, which is limited to just this case, my experience is that in Fulton County, the judge is going to go, oh, well, we have so much time invested, let's move forward. Okay. If that's the case, if she chooses to move forward, then all of these do matter. All of these pleadings and petitions that I've been, or pleadings that I've been reading to you this morning, that besides the mistrials, do matter. I don't know. We saw the judge in Rust, and we saw that judge hold the little hearing. You know, the judge saw that it was learned that the evidence had been. The judge learned that the evidence had been withheld by the prosecution, and she declared an immediate mistrial with prejudice, aka attaching double jeopardy. Okay. All right. We have the Steele motion. Y'all, round of applause for Boleyn. Boleyn is so amazing. I'll send her a message like 6 p.m. on a Friday, be like, I think they filed something. And then, boom, she's got that filed to me. She's amazing. Boleyn, I love you. Okay, here we go. Here is the motion to correct discrepancy concerning Mr. Williams' trial exhibits. All right. After review of the YSL exhibit status Excel spreadsheet provided to counsel by this court, Williams has identified the following exhibits which were admitted but not recorded. Okay. DW1. What I love about this is that he says, click on the YouTube at this timestamp. DW2, click on the YouTube at this timestamp. Here he says he's still analyzing potential discrepancies in the state exhibit. At the time of the filing, it is believed there are approximately 100 exhibit discrepancies. So the state didn't learn its lesson? So the state wants to continue to play dirty games? 100 discrepancies? Are you effing kidding me? DW3, DW4, DW7, DW22, DW26, DW31, DW34, DW35, DW42, DW43, admitted over objection. This exhibit was played for the jury. Played for the jury and didn't make it onto the exhibit list? Are you effing kidding me? 44, 60 and 60A, 61, 62A, 63, 64, 65, 66, 69, 70, 72, 222A. Those are all admitted. But the prosecution didn't tell the court that. Oh, hey, new court. So this is a great example of why this new court cannot just take over. Because this new court cannot trust the prosecution to tell the truth. I mean, if this judge looks at the totality of these motions and reads this before she decides the mistrial, in my mind, I'm the judge, I read this, you sent me an exhibit list that didn't have XXIV worth of, I don't know what that means, like 24 or something. I didn't pay attention to Roman numerals in school, which, you know, as an adult, like every time the Super Bowl comes around, I'm like, I should have paid attention, okay? But if the judge sees this and that the prosecution left out 26 items, how is and looks at Harvey's point, Bruce Harvey's point was, how are you going to know everything that happened in this trial? And I would add to that point now, how are you going to know everything that happened in this trial when the prosecution keeps lying? The only way they can win. The only way they can win is if they lie. Please. All right, I have to send this text. I have a home issue. Okay. All right, here we go. Here, I don't take a case that I have to lie to win. I like winning, like raw dog winning. I like just being right. You know, like I don't want to lie. I'm going to be perfectly honest, because even if I have some negative, something to overcome, it is far more enjoyable to win on my ability of winning. Okay. The following exhibits were not admitted at trial. However, the court reporter has marked them as admitted. DW8 and DW10. The following have been admitted in the case of bar, but they're not listed in the status spreadsheet. Have been admitted, but not listed. JW222AB, JW222ABR, JW233, JW229R. Sorry, it's just exhausting. I'm sorry, it's just exhausting. I am exhausted. Because the state keeps lying. The state has to lie to win. The state cannot win without lying. That's some bullshit. Okay. That is exactly what our Constitution protects us from. This kind of bullshit. And being held perpetually by the government. This is what the Constitution protects us from. This is what the Founding Fathers were concerned about. This exact thing is what our Founding Fathers were concerned about. All right. So, back to the state's response, assuming facts not in evidence. Arguments. At the outset, he never provides authority that inquiring to unproven and irrelevant areas. Facts not in evidence classifies as a specific mode of cross-examination imparted by constitutional requirement. She actually cites some case law. Even grounds that are constitutionally protected, however, may be subject to judicial control. Wow, cited some more case law. Holy sh... Fifth Circuit has made it clear that questions which assume facts not in evidence are not constitutionally protected and subject to exclusion by trial courts. Williams' motion attempts to constitutionalize areas of cross-examination that is not so protected. Even assuming, arguendo, that the questions assuming facts not in evidence were of the same stripe as an area like bias, 401, 403, and 611 would preclude Williams' proposed inquiries. I really wish I knew what motion they're responding to here. Pursuant to OCAJ, the trial court has correctly prohibited Williams from posing questions that assume fact not in evidence. Jury proceedings shall be conducted to the extent practicable, so to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Courts are mandated to exercise reasonable control over the mode and order of interrogating witnesses and the presenting of evidence in order to make the interrogation and presentation effective for the ascertainment of the truth. Reading these statements in conjunction with one another, courts are authorized to prevent counsel from asking questions in the hearing of the jury that are premised on inadmissible evidence to facilitate ascertainment of the truth. The one where they couldn't cross about the plea deal being thrown out due to coercion. Oh, okay. Okay. So I'm guessing then, Resins, these are the responses that they should have written months ago, but we're just seeing them now because those were questions left open-ended by Glanville? Is that what's going on? William asserts that the court's sustainment of objections for questions that assume facts not in evidence curtails his Sixth Amendment right, but cites no legal authority. Case law explains the Sixth Amendment provides two types of protection for a criminal defendant. This is important, y'all. Pay attention to this. The right to physically face those who testify against him, and the right to conduct cross-examination. Okay. The reason that's important is because all of us, the Sixth Amendment applies to all of us. And so we should understand how the Confrontation Clause works. Oh, Steele did this motion last week. Okay. The Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and whatever extent the defense might wish. Furthermore, trial judges retain wide latitude to impose reasonable limits on cross-examination based on concerns about, among other things, confusion of the issues or interrogation that's repetitive or only marginally relevant. All defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state has called to trial. That's a lie, because they were not afforded the opportunity to know what went on in that ex parte meeting. The state will not object to cross-examination that's legally sanctioned. Williams' right to cross-examination is not abridged where the examination is limited by the trial court to relevant matters. Objections to assuming facts not in evidence are proper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they're considering information that's never been properly admitted as evidence. Wow, she actually cited another case. Holy crap. Holy goodness. There's actual... I bet she didn't write these. My guess is Attorney Love didn't write these. She signed them but didn't write them. Defendants Williams' improper questions, which assume facts and evidence, could confuse the jury during deliberations. Appellant enumerated as error at trial counsel's failure to object to the prosecutor's questions of a witness which improperly assumed that these defendants had created the mess, a fact the witness did not know and which was not directly in evidence. Ultimately, the court held the trial counsel's failure to object to these questions could be qualified as a reasonable strategic decision and did not find prejudicial error. Nonetheless, what does that have to do with it? Nonetheless, the fact the Supreme Court diligently undertook analyzing appellant's objection to improper questions that assume facts not in evidence underscores the validity of such an objection. Williams classifies such objections as specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. Moreover, Williams seeks to ask questions that imply matters that at best Williams cannot substantiate. For example, Williams asked Belknap, do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? Now, those facts might not have been in evidence at the time, but I know for a fact that Williams, YSL Steel, is going to put on a expert that will testify to that. To begin with, this question is predicated on a falsehood, as this court's detailed order on the introduction of gang lyrics proves this is not a true threat case and not one defendant is being prosecuted for expressive activity of any kind. Bull. Plus, this line of questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants' lyrics at trial. I actually agree with her on that. If Steele wanted to, he, in his case in chief, could put on his expert that talks about that prosecution and then recall the police officer and then ask the cop that. But him asking the cop that before was in fact bad form. So that's true. I agree with that. I don't love it, but I don't love anything that Miss Love does. Williams' counsel asked Rassy if he knew Dolly was in a relationship with Jimmy Winfrey. State objected because there had been no evidence. Williams does not have a right to float unsupported and unsupportable distractions using sworn witnesses as a vehicle. Therefore, his request to prohibit this court from sustaining any further objections to questions that assume fact and not in evidence should be rejected. Okay. Next. State's response in opposition to defendant's motion for correct ruling on adoptive admissions. Defendant Williams does not request specific relief. Whatever. Okay. Argument and authorities. Sending Georgia's former ban on their introduction to oblivion, the Supreme Court of Georgia, in accord with federal precedent, approved the introduction of adoptive admissions in criminal case. Oh, okay. So, do you remember St. Nikki Hilton, patron saint of courtroom patients, she had asserted that several of the witnesses had adopted admissions her assertion that they were adoptive admissions were that the witness did not object to the statement at the time the statement was made. That's not an adoptive admission. The way St. Nicky Hilton did it was not correct. It was not an adoptive admission in that manner. So I'm guessing that that's what this motion is about. Okay. The state's briefing argument, this court, an order on the introduction gang lyric evidence, the concept and application of adopted admissions were delineated in considerable detail. The state incorporates that material by reference and provides the following in some summary and supplemental response. Rule 802 authorizes previous court ruling on introduction of adopted admission and governs trial court consideration of the same. Admission shall not be excluded by the hearsay rule. An admission is a statement offered against a party which is a statement of which the party has manifested in adoption or belief in its truth. Defendant Williams is partially correct in asserting that mere silence to a party opponent in the presence of another, standing alone, does not equate to adoptive admission. Okay, I was right. That's what they're talking about. However, a defendant's silence may, in certain circumstances, communicate that he has adopted another person's statement as true and make that statement admissible. But what if the person didn't hear the statement and they just ignored it, or they ignored it because it was stupid and we don't negotiate with terrorists? Like, I ignore people all the time. That does not mean I agree with them. It means I'm ignoring them. In evaluating whether evidence qualifies as defendant's adopted admission, trial court must use two criteria. Statement was such that under the circumstances an innocent defendant would normally be inducted to response, and there are sufficient foundational facts from which the jury could infer that the defendant heard, understood, and acquiesced. Well, guys, as I recall, we had number one, because, you know, it was, I remember there was some assertion like he's in a gang, and allegedly the defendant didn't say anything. Now, this is the thing, though. People can accuse of a crime like, oh, he's a murderer, and then you could even say, oh yeah, I sure am, and not actually have murdered anyone, right? Like, there's this sarcasm, there's jokes, there's all kinds of things. So that's why there has to be sufficient foundational facts to infer that they heard, understood, and acquiesced. And that's what lacked in this case. I do not believe that that was the case. I don't remember hearing any of that. After this initial determination is made by the trial court, the jury is responsible for making the ultimate determination. An example is found in Wilkins, where the court found it reasonable that a statement referring to a bloody shirt in the trunk of the car, the shirt we use to wipe blood, and fingerprints off a gun is the kind of statement that would normally prompt an innocent person to clarity that that was not part of the we. I don't like that. That's very nuanced. Like, language and discussions and like group settings and talks, you're not gonna hold on, guys, you said we, but I'm not part of the we. I don't know. Okay, foregoing said, direct confrontation with the accusatory statements is not always coupled with lack of denial. Example cases. Wow, they actually read some fucking cases. Congratulations. The court's prior rulings on adopted admissions have been made. I don't think so. I disagree. I don't think she proved the second half. Remember, they have to do the foundational. I don't think they did that. I don't think they reached that threshold. Okay, the next one. This is the defendant's motion to correct ruling on self-serving hearsay. I hate self-serving hearsay. Like, that's some shit straight out of Georgia. Well, I've never even heard that term before I started watching this trial. Like, it's so ridiculous. But I Googled it. It is a thing, I guess. Okay, pursuant to legislative act, hearsay is redefined as a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. If you guys want to know about hearsay, I made a whole video on it. Please go in there. We talked about it a lot. A party may not introduce his own statement unless the hearsay exception applies. That's so weird. If you are a party, you are able to introduce your own statements. Like, that seems wrong on a federal level. It seems like Georgia, because this is out of a Georgia case, right? It seems like Georgia got that wrong. Like, that seems to me to violate federal hearsay. Accordingly, self-serving statements where parties attempt to introduce their own prior statements absent an applicable hearsay exception are routinely determined inadmissible. I'm glad I don't live in Georgia, y'all. What a shithole. My God. I'm glad I don't live somewhere with Rico, because that is so stupid. You know how many times in the family group chat my kids and I have called each other gang? Do you know that once a year I make them wear the same colors as me and get photographs? Do you know that we call each other gang and wear the same colors sometimes? We definitely work in the furtherance of our family. I don't like it. I'm glad I don't live in a RICO state. I would never live in Georgia. You couldn't pay me. Especially after reading this. This is crap. The court correctly prohibited Williams from eliciting self-serving hearsay, and the burden's on the moving party to establish one of the hearsay exceptions. Williams has not made any offer of proof demonstrating that Williams can satisfy any hearsay exception applied or that he's introducing this evidence for a non-hearsay purpose. Therefore, his statements are inadmissible, whether or not they're self-serving. It does not extend to a party's attempt to introduce her own statements through testimony of other witnesses. So, if I say I'm innocent to Boleyn, then I can call Boleyn to say that I said I was innocent. The court correctly sustained state objections to self-serving hearsay because Williams failed to address, much less overcome, his burden of proving a hearsay exception applied to his self-quoting statements. He asserts he primarily wants to introduce his lyrics and social media postings. His self-quotation of his own lyrics and social media postings are inadmissible. Okay, here's the other thing. Why? One thing I don't like is, like, I try to take cases that I can prove with just a nominal amount of evidence. I talked about this in a past video. I was preparing for trial. I didn't think I would be able to get the witness I thought I was getting it under, and I did. I found a way to get it under another witness, right? Like, that is part of the job of being a lawyer. So that motion seemed, or that response seemed pretty much meaningless to me. And unpopular opinion, to your point, like, what? I don't know. I thought the local government in Dallas was bad, man. Jeez Louise. All right, here's our last one. Thank God. On June, he ordered the court to correct proper rulings on state objections precluding cross-examination with vague questions. Okay, so like the beginning is always the same. He never provides authority that inquiring to vagaries classified as specific mode of cross-examination imparted by constitutional requirement. Even grounds that are constitutionally protected, however, may be subject to judicial controls. Oh, haven't we already read this? Oh, they're just copied and pasted the same shit again. They just changed the word to vague. Okay, jury proceedings shall be conducted to prevent intimate. Okay, like, again, they just quoted. They didn't change anything? Have curtailed his Sixth Amendment but cite no legal. This is exactly the same motion we just read. However, I just read this. Y'all, if I'm the judge and you just copied and pasted a motion I just read, I'm pissed. I am pissed. I have to wear glasses because of law school. If I have to read extra shit that was my eyes, I'm going to be mad as hell. I'm going to be so mad. Vague questions are improper. Okay, here's something new. 11th Circuit held that a question or phrase is ambiguous as a matter of law when it is not a phrase with meaning about which men of an ordinary intelligence could agree, nor one which could be used with mutual understanding by a questioner and answerer unless it were defined at the time it was sought and offered as testimony. Vague questions are an impediment to the ascertainment of the truth because such questions left undefined by the questioner prohibit mutual understanding to the meaning behind any answer by the witness. Repetitively proposed vague questions by Williams foist cluttered confusion on the jury, whereas an unambiguous proper question provides the jury with concise clarity of the facts and better equips them to ascertain the truth. Hilarious that the prosecution is talking about concise clarity when I've been watching this entire trial and I have no idea what they're trying to prove. Federal courts have repeatedly upheld objections to vague questions of the type of commonly asked by Williams. Plaintiff properly objected, which were vague. It is paramount for courts to sustain objection to vague question because the trial courts bear the responsibility of making an interrogation effective for the ascertainment of truth. The prior objections the state has lodged at inadeptly phrased vague questions asked of witness by defendant Williams have correctly been sustained by this court to facilitate the ascertainment of truth. For example, Williams asked the Lambda Police Department detective, "Do you know there are videos of countless performers or athletes where they're promoting their trade?" That's not vague. What is vague about that? The state objected to this question because it's vague. The question was ambiguous. It's unclear as to what video, which performance, and what trade they referenced. That's not vague. All right. God, I'm so glad I'm done with that. I can like hear her voice in my mind when I read her stuff, and it's just so gross, dude. She's just the absolute like worst. Ugh. Unpopular opinion said their whole trial and investigation has been vague and repetitive. There is no doubt about that. There is no doubt about that. Woo, what a freaking mouthful. Okay, so on Monday of this next week, I'm going to go live and talk to you about the ballerina trial. I'm going to do the whole recap, okay? I'm going to recap that whole trial. It should be done by next week. On Tuesday, these folks will resume in the courtroom. I will be on an airplane, but I definitely will tune in. Hopefully we see a mistrial. I'm guessing we're going to have a mistrial called because I can't really imagine. I can't imagine it not being called. I mean, there's just so much stuff to call a mistrial on, particularly the fact that you're going to have to explain to the jury that there is a new judge. That doesn't even make sense. So Tuesday we'll see that. Friday, I will come to you on a brief live to discuss a recap of what happened Tuesday, Wednesday, Thursday. Maybe there's nothing Wednesday and Thursday. Maybe the mistrial. Maybe it's called. I don't know. We don't know. All right. CJ says, I wonder how many juveniles were impacted when Love was a juvenile judge. It makes me sick to think that she was a juvenile judge. It literally makes me sick. Like, ugh. That woman should not be a judge of anyone, particularly children. Particularly children. I agree with Terrell. If the judge does not call a mistrial, they will move into bond hearings, and I do believe this judge will allow them out on bond. There is no reason these men should not be out on bond. None whatsoever. None. I can't even think of one. So hopefully we see her release them on bond if she does not declare the mistrial. I would be very surprised if mistrial is not declared, although, you know, it is Fulton County and they do sketchy shit there. So who knows? All right. Friday I will come live. Monday I will do a live. Friday I will do a brief live while I'm on my vacation because I care about you so much. We're going to update. Then the next week I will be back to normal life. I will be back to my Friday lives. Then the week after that, on August 13th, I will be in Atlanta. If the trial is continued, I will be in the courtroom on the 13th. Sometime in the afternoon I'll get there. And we will have our meet and greet at 6:30 p.m. at the Hudson Grill downtown. And that will happen the evening of the 13th. If this trial is resumed and going on the 14th, I will watch with you in the courthouse on the 14th. Okay? When I return, I will be launching my merch store for real. We have merch. We have a merch store. Feel free to check it out. But we'll do a full launch. I'm working on the membership and membership levels, so I definitely will do that. And I think that's it. I am trying to get to 10,000 subscribers before the end of the year, so if y'all will share my information, if you have any friends that are trial geeks, you know anyone that's interested in this stuff, I would love that. I'd appreciate it. I want to say thank you to all my members. Thank you to my mods. Thank you so much to my mods. They do a wonderful job. I have not had any weird comments since I've had the mods, so that's great. Oh yes, Monique, I will go live at the meet and greet. Yes, I will. I got this fancy camera, and part of the fancy camera is that it's portable, and so I will take it to the meet and greet, and we will stream live from the meet and greet. I do expect 2 other YouTubers to be there. I expect Steady Nash and Sylvia, infamous Sylvia, to be there. All right? If they don't show, they don't show. I know Steady recently lost a family member, and our condolences to him. Thank you everyone that has hit like. Thank you everyone that has hit subscribe. Thank you everyone who's told me to have a nice vacation. I appreciate it. I will try my damnedest. I think it should be fun. I'm looking forward to the high being 75 and the low being 60. I actually just really excited to wear my hoodie. I just really love hoodies, and I love hoodie weather, so I'm very excited to go to the hoodie weather. Thank you again everyone for being here today. I appreciate you all so much. I love, 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 love meeting with you on Fridays, so thank you. I don't know what time I'll go live on Monday, but I would expect probably early afternoon. Keep an eye out on YouTube, and you'll see that on Monday. I hope to see you. Otherwise, I will definitely see you next Friday.